Will be about source of funds. It's titled "How Much Is Too Much." Can everyone please calm down?
Hi, everyone. Good afternoon. If everyone can please take a seat. Thank you. Well, thank you all for being here. I know we're still in the middle of lunch, but I do promise we do have an exciting panel for today. We're going to be discussing how much is too much when you're sourcing funds for an EB-5 petition. To my left, I have an amazing group of attorneys, very experienced, and I'm going to have each of them give a brief description of themselves. I'm going to start with you, Nima.
Oh. Hey, everyone. I'm Nimo Corpivara. I'm a partner at David Herson and Partners. We're an immigration firm based in Los Angeles and Seattle, specializing in the EB-5 program.
Hi, I'm Genevieve Roman. I'm also an immigration lawyer. I work here in New York City, in-house for a regional center, Extel New York Regional Center.
Good afternoon. My name is Dan Schwarz. I'm a partner at Fragaman Immigration Law Firm here in New York. Been with the firm for about 13 years now, doing all things U.S. immigration, including, of course, EB-5.
Good afternoon. My name is Jinhee Wild. I am the principal and managing attorney for Wild & Associates, based out of Washington, D.C. area.
And I'm Rebecca Singh. I'm a senior associate with Mona Shaw Global, and I've been doing source of funds for a very long time. So we're going to just go ahead and delve right into it. Jinhee, if I was going to go ahead and begin an EB-5 petition and source an investor's funds, what do I look to? Where do I go?
Well, we have, the regulations are fairly broad. It says that the source of fund has to be legal, but it's not that difficult if you have a tax returns and Western banking system, but many of our clients come from areas where they do not have tax returns, and they do not track of where their money is coming from. Many of the small businesses overseas do cash business, so it becomes very difficult to track. And USCIS now is looking at longer and longer time period, looking at the original source of the money. And that could be as far back as 20, 30 years ago. And many of the documentation doesn't exist, so it becomes very difficult. It needs a careful planning and careful research.
So do the regs tell us in detail what we're supposed to submit to USCIS? This is based mostly on our experience, right?
Right, right. I mean, it would be nice if the regulations tell you that we want to see 3 years of tax returns and, or 10 years of tax returns, and we want bank records, monthly bank records. It doesn't do that. I think it's more vague, and it just gives a parameter that we can interpret. And unfortunately, as we have seen a couple of years ago with indebtedness issue, the interpretation could be different from what we are interpreting, and USCIS's guidance change. So.
Yeah. So the regs really just say, list basics, foreign records, they'll have, tax returns, not how many years. But my favorite line is just evidence identifying any other sources of capital. So it's very vague. But Dan, we have policy memos. Has that helped or guided us in any way?
We do have policy memos, and those policy memos are, I'd say, essential because they do point us in a direction. I don't know that it's more than that, which is a general direction of go this way. And they shift, as you're going to hear about a little bit on this panel. We think things are one way, and they are for years, and then suddenly they're not. Which sounds crazy for people who aren't in immigration every day, but in other contexts of U.S. immigration, that's how it goes, right? The agency will decide, no more, we're going in this direction. And it doesn't need to be rulemaking, right? So it's new policy memo or old policy memo rescinded, new policy in place, figure it out. So in terms of the policy memos that do exist, I think for me at least, the value and what I try to reference back to immigration a lot is the standard, right? Which is not clear and convincing, it's preponderance, right? And that should be huge, right? More likely than not. And the policy memo even gives an example of, even if the adjudicator has reason to doubt, right? If on the whole, it's more likely than not that it's okay, it's okay. That's pretty strong language, right? Even if there's a reason to doubt, still approvable if the facts indicate, some factors that make it make sense. So I really try to emphasize that in responses to RFEs, both in EB-5 and in other contexts where that standard applies, because it's important and it's valuable as you have to appeal things upwards as you get out of immigration and into maybe federal court. That standard is important, and to keep retracing it and reminding the government of their standard and how it should apply to you is important. And just as an example, I think we've all probably seen the RFEs and the notices of intent to deny based off what to us are seemingly minor discrepancies, right? The month that the person started employment or the year from 1999 or 2000 that the person's employment terminated. And there's the notice of intent to deny saying, see, your visa application from 15 years ago said it was 2000, you actually stopped working in 99. That gives us reason to doubt the veracity. When otherwise, we've got the bank statements, we've got the employment letter, we maybe even have the tax returns. So, those factors and the preponderance of evidence standard, I think, is really important for practitioners to remind the government of at each opportunity.
Well, Nima, the regs also state that, we have invested versus actively in the process of investing. Have you dealt with cases where you've had to differentiate, or do you know of any cases where we had to have more documents to show that is this person really actually investing? What's it mean for investors?
Yeah, so with all things EB-5, there's the regulations, there's what the market requires, and then there's the adjudicative standard. The regulations do not require full investment at the time of I-526 filing. This is hugely beneficial for an investor because not everybody is 500,000 or $1 million liquid. Maybe you need to sell a house, you wait for a bonus from work, maybe you're getting a divorce settlement, lucky you. And because the processing times are so long, you have to make a life choice, right? It's maybe 2.5 years before I get into the US. My son or daughter is going to turn 16. I need to get in line even though I'm not liquid. And so the regulations say you need to show you have an intent to fully fund, and then that fund is going to be irrevocably committed. So how do we show intent? As an immigration attorney, I'm not as well versed in securities and contracts law, but the investor is signing offering documents, right? They're signing a subscription agreement, an operating agreement, potentially an escrow agreement that has funding requirements. And in addition, we require a declaration that says, hey, here's where my money's going to come from, here's my funding schedule, here's my signature. And then whatever we identify in that declaration, we want to see evidence. So if you're going to sell a home, well, give us your deed, give us an appraisal, maybe show us you have a listing with a real estate agent. So when you compile all these documents together, you're saying, hey, I'm on my way, let me in. The issue that you run into, though, is regardless of what the regs say, if you're not fully funded by the time your I-526 is ready to be adjudicated, you're going to be denied. USCIS is going to issue an RFE or a NOID requesting full funding, and if you're not there, go home. The other issue you run into is you need to subscribe to a project. And if a project is really attractive, they may not hold your spot for you for a year and a half, right? Maybe they'll hold it for a month, but a project is in the business of getting investors. So maybe you have to go to a second or third class project.
Yeah, exactly. So Genevieve, speaking from you're coming from the regional center point of view, do you accept investments, partial investments? Do you hold spots open for investors that, looking for their second funding?
We accept partial investments, but we don't have people filing 526s on a partial investment. And we try to accommodate investors as much as possible if they've partially funded and they have a strong preference for the project, but we can't really hold spots for people.
Yeah, because it makes it hard for a project to move forward if you don't have all the funding or what you're relying on. So just for us, because we've done this from our experience, for our firm, we create a individualized checklist for our investors. And so each investor has a different source. Not everyone is going to be the same. You're coming from different countries, different backgrounds. Ginny, tell me, how do you go about figuring out what to get from each investor?
That's a good question. It depends on what the investor does for a living, how they gather the funds in the first place. As a EB5 lawyer, you end up asking a lot of personal questions to your clients that may not have even signed up with you yet. You ask. But I think that what I would like to see from the USCIS is a little bit more common sense approach to looking at source of funds. If you are telling the USCIS, this is an investor who has been an MD, has a cardiac practice, and has been practicing for 30 years. And, he is liquidating one of his buildings. You don't really have to ask, what funds did you have 30 years ago to buy a building? I don't usually get RFEs. I had 3 RFEs on source of funds in 10 years of EB5 practice.
Show off.
I know. But one of the RFE was a client with a multinational company with a multi-million-dollar revenue. He had received a dividend from the company and used that partial part of that to do the EB5 case. And the RFE was issued asking, with what money did he establish this company 22 years ago? Luckily, we had the answer to that, but we had provided audited financial statements as well as 7 years worth of tax returns in this particular case. So I think that is a very prime example of what is too much.
And affidavits and declarations don't really work in those scenarios.
Not really. Yeah.
Nima, what about, and Dan, do you guys work with multiple sources where an investor has, I have had clients come with 6 different sources. Do you feel that you need to have more documents to show that, yes, these are investors, they have the money for this, or do you try to limit certain documents to each?
Yeah, so multiple sources is unfortunately unavoidable sometimes, although I really try my best to try to avoid it. So if they come with, okay, it's going to be these 5 sources of my wealth that are going to be the 550 or whatever it is with the admin fee, I usually say, okay, we can do that. It's going to be painful. Or is there anything else, right? Is there a home equity loan we could use? Is there something that you haven't thought about in terms of your wealth that maybe we can get a little bit more bang for our buck on a single or 2 instead of 5 sources? Because it gets a little bit wild. And if it's wild for us, imagine for the adjudicator who hasn't been sitting with this person for hours mapping it. So it starts to make sense with us when we've been in the weeds. For the examiner who gets it and is looking at it for the first time, it's like, whoa, it's a lot to handle. So we try to take the spoon feed approach as best we can and a less is more approach in terms of trying to be precise with the documents and limit the documents instead of here's everything, sort through it and figure it out, right? I think that's a bit of a recipe for RFE, obviously maybe. But that's the approach we try to take, and I imagine that's common, to try to dissuade those multiple sources to the extent that you can.
Yeah.
You learn as an attorney, if you send an email and your client writes anything back besides, I understand, thank you, you messed up along the way.
Yeah.
And so you need to know your audience, right? Yeah. If I have a client from the Middle East or China, I'm not asking for tax returns, right? That's a waste of money. Yeah. If I have a client from India and I try to get them to source where they got all this gold from, we're just going to have a laugh. So you really need to tailor, your document request country specific. And then if we have multiple sources or we have a lot of holes, then it's a negotiation with USCIS. You know, I'm not going to ask you for any more documents. Let's send it in and we'll negotiate. They'll come back with an RFE pinpointing what's available, and maybe we can come up with half the docs. And you're like, look, you were at $1 million, I'm at 500,000. We came up a little bit. You know, you need to approve it. That's kind of the state of play. You know, and you're always going to have an investor that wants to push, even if the documents aren't there. So you go with what you have, and you know what's really important is, there's an officer at USCIS that's reading this and adjudicating this, right? If you can tell them, hey, this is what's going on in this part of the world, right? In Turkey, you know, the president is becoming a dictator. Maybe you're not going to be able to get out of there quickly with all your papers, but you want to leave. In Egypt a few years ago, there was a revolution. The banks were shut down. So maybe you have to give cash. Trying to give a context to where this application is coming from is important, because oftentimes if your life is amazing in the country you're not in a rush to come to the U.S.
Exactly. So what we like to do is give a background. You know, our source of funds memos can be pages. I know a lot, and Genevieve, I'll ask you this, and we'll move forward. A lot of attorneys, like literally a paragraph on the source of funds, and there's no way. You know, we give background information. If we don't have the necessary documents, you know, what can we come up with to make sure that this application is going to go through? So we do have a lot of research and background information on our investors, who they are, where they're coming from. So USCIS can have an understanding of, you know, where they're coming from. So Genevieve, I know with you being a regional center, you guys are getting, you know, tons of applications every day. What is your strategy?
In terms of
reviewing, and you know, do you guys review? So do you review do you yourself, or you know, your in-house attorneys review the the source of funds documents coming in?
I review the majority of the 526s that are being filed by filing counsel. We also have, occasionally it'll be an outside firm, or I'll, you know, co-counsel and talk with our 924 counsel about cases that are a little more complicated, but we provide a review at no cost to the investors, and we think that it really is a best practice for all regional centers. The I-924 specifically asked the question, is the regional center engaged in a due diligence screening of the investor source of funds? So I do think it's important. I think it's good to have just another set of eyes on the applications.
But that is not to say that the filing attorney should rely on you to
Exactly.
set stuff, right?
Certainly not.
Yeah. But do you see an array, you know, differences in attorney filings? Are you getting, you know, 5-6 pages of source of funds and then, you know, a paragraph, or do you guys have a template that you give out? What do
Yeah, that's a very interesting question. I started doing this in 2011, and you know, I've reviewed probably more than 1,000 526s in that time, and I see a lot of different work product. It's really across the board. One thing I will say that I've found interesting is that sometimes less is definitely more. People who provide a lot more information, a lot more detailed descriptions and write-ups may get RFE'd, and people who have a very short you know, few paragraphs, but they include all the exhibits, just get approved. So,
Well, I think it's important to say that when I first started on my first EB5 case was about, you know, less than half an inch thick. Nowadays, from the regional center, business documents are about this, and source of fund documents could be 2-3 inches high. So when you are sending a 9-inch worth of documents to the USCIS office, that officer has to take a look at, review all of these things. And we have over 20,000 I-526 pending at USCIS. I mean, these poor officers are being buried in paperwork. So from the practitioner's point of view, if you want your applications reviewed, I actually err on the side of give more than less, but giving more also means more paperwork. So you need to actually have a summary sheet or something with the exhibit pointing to a particular exhibit that you're trying to alert the USCIS officer, and make it easy for them to review that 9-inch worth of documents.
Yeah,
I think that is the most important thing for us as the practitioners to avoid RFEs and make it easier on the USCIS officers.
I agree. I don't encourage less is more. I think the most detailed and thorough information possible, but also certainly a roadmap and cover letter that's very explicit and easy to understand is really, really helpful.
You know,
Yeah.
in the same vein, it's interesting to see when you file with different regional centers, the different review, right? So there's some that are super careful and asking for things in addition to what the reg requires, right? Or what the policy, or what we think the reg and policy memos require. And others who take a much different, I don't call it hands off, but less of an approach. And I think that's fine. It's whatever, that's how people are. But perhaps, and this is where our conversation started, a bit more guidance from this immigration service would help to level that, right? And then we're not having inconsistencies with what officers are getting, with some piles like this and some like this and some like this. And then obviously that's going to mess with timelines and being buried in paperwork, to Jinhee's point. So I think it all kind of relates back to that same issue, where the regional centers have to be cautious, right? You get 1526 denial, then word of that spreads in China, ball game. So you've got to be really careful. And that inconsistency is really hard to manage, I think.
Yeah, I know with our practice, every document that comes in, you question why. Why do I need this application or this document? What's the purpose of this document? If there's no purpose for it being in there, then you don't need it. But everything should be explained. You know, every exhibit that we have is explained and detailed as to why it's evidencing why this source of funds is legal and lawful.
You know, not to interrupt, but exactly interrupting. But, you know, one other thing to keep in mind is sometimes your client has an aging out child and they need the process to take as long as possible.
Yeah.
They're like, hey, I need you to file a crappy filing so we can get an RFE and extend this out so we can calculate back and my child won't age out, right? And so that's something to keep in mind too. How do I file a poor case but not poor enough that it gets denied, and also the regional center will accept it, you know, on my word or the client's word that we'll supplement the filing at a later date.
Yeah, that's a good point.
I'm
Well,
here all week.
well, Neem, I'm going to come right back to you. You know, I know we touched on this a bit, but you know, the whole understanding. I know when we were speaking before that it's the countries, but USCIS needs to understand, culturally understand where the investors are coming from. Right? I know you had that. You had your opinion on that one.
Yeah, I mean, you know, USCIS, if you look at the regs, what their examples for documents are primary documents readily accessible in the United States, right? I'm Iranian. I deal with investors from Iran. You know, the idea of a Western banking system or a non-government controlled banking system, that's pretty silly. The idea of capital flight outside of the country, that's not possible. You work in what, you know, is termed a black market, where you find different transfer houses to get the money out for you. You know, and officers don't always know, right? A lot of the officers are actually veterans of the United States. They've lived in the U.S. their whole life. They're not aware of the banking systems in these other countries, nor was I before I got into this. And so it's really important to paint a picture, right? I mean, if you're fleeing Egypt because there's a civil war, you need to explain that, because otherwise you're not going to have tax returns, right? I mean, in China, actually, it's really common for banks to merge and all the other records to be purged. And so we often look to other areas of immigration. You know, in the EB2 and EB3 categories, if your company no longer exists, well, you can get employment letters from 2 or more people. And if they attest that they knew you and your position and your salary, that's verifiable. The regs also say if a document is not available, but you can prove that it's not available, then it's as if the document was there, if that makes sense. And so a lot of it is explaining to the officer, look, we tried to get these documents, they're not available. I got these secondary docs. Look, my house was in the newspaper, you know. These are all these photos from my business over the last 15 years. I don't have the registration docs. I don't have the bank statements. But look how happy these employees are. I was a great boss, you know? And you got to paint that picture, because it's like Dan said, the standard is more credible than not, right? It's not, you're not convicting someone of murder. And so you just compile all this stuff to get it through.
One thing that I think we all on this panel, as well as most of you out there, we strive to meet the regulations and policies, and we follow it with the best practices in mind. So I would like to hope that USCIS, understand that that's what we are trying to do. So even though you may have doubts, understand that we are trying our best. So if you can give us the guidance as to how better to do it in your eyes, we would be happy to follow that.
Yeah. Yeah, I know we had, and I'm 100% with Nima on this point that, we just filed a source of funds with, someone from Turkey. And, they're trying to get out the country as fast as they can. There's other issues. And, we're nervous because we're like, well, they can't gather all the documents. The sun is aging out. What do? We know for sure we're going to get an RFE, but USCIS is not going to understand from where we're coming from.
And EB-5 is definitely the slowest way to get out.
Yeah. Well, so let's take it back. So I started in 2011 as well, and I remember when we were filing documents. To me, I felt like it was easy, but now as we're going, I feel like things are becoming stricter, and they're vetting these documents more. What do you guys think?
I mean, no doubt. I mean, it's all about, and Nima kind of said this earlier, where the person's coming from, right? So where you've got somebody who's lived and worked in the U.S., maybe he's in the green card process, backlogged for EB-2 India, and says, I can't wait anymore, EB-5, W-2 income tax returns, high five, that's a good case, should be no problem, right? And that's true. That's great, right? And then you've got cases that go further away from that on the spectrum to the cases, and I'm thinking about particularly markets that are, say, exploded, like Vietnam, where the market has changed so much in a short period of time, and the culture has changed from a banking standpoint, where to us, something that's 15 years old is, well, why can't you get that from the bank? Whereas not so much in some of these other markets that have developed so fast, right? And I think immigration is reacting to that and maybe applying a standard without understanding what's available from those particular countries, right? So it's painting the picture in a way that makes sense, giving the context. Vietnam is a great example, but India is too. There's several where getting bank statements from just 15 years ago, again, in the United States, why can't you get that? It's not even close. There's absolutely no chance. And same with property appreciation. How did you acquire that property in 2002? And why is that hard to document? It's hard to document. And you've got to rely on the secondary sources, and the preponderance of the evidence test is what's going to carry the day there.
Well, I think many European countries even, you're not required to keep tax returns for more than 7 years. So if you are having a audited financial statements, those auditors don't keep those records beyond 7 years. And so asking the client to get these documents on an RFE going back to 20 years, 30 years, may be a little bit too much.
I mean, even here in the U.S., we're not required to keep bank statements for more than 7 years. And even as an attorney, we don't have to keep a file for X amount of years either. So I don't know, they can't expect someone else to do that as well.
No.
Yeah, I would add, I took a little informal poll of some of the filing attorneys before this panel, and I was asking, is there anything that they, thoughts they have? And of course, I do think that things are getting more burdensome in terms of what kind of evidence is required, and it's, but the main thing that people out there filing are saying is just they're getting these RFEs for all kinds of information under the sun, and they're like, we want to, as Jinhee was saying, we want to follow the rules, we want to do this right, we want to be thorough. Are these documents really necessary for USCIS to adjudicate this petition? Do they really need this? Because it's very burdensome, and people are jumping through all kinds of hoops to get all this extra information, which really, at the end of the day, what people really need is just some guidance, like something more clear.
Have you guys seen any difference? We do have a new administration that came in this year. Have you seen a difference of? I know we are seeing a difference at the consulate stage, but what about the source of funds stage?
I personally haven't seen too much difference. Again, I don't get RFEs, but that is not an invitation for USCIS to give me more RFEs, though. But I think that, unless we are in a situation where my one and only denial stemmed from the fact that a case was filed before the indemnity issue policy, and then having that case denied was a real jolt into my ego. But I think that if we are going to change policy or enforcement of Izumi or matter of Ho in a different light, after many years of doing it one way and then changing, again, I would like to see a little bit more of a preponderance of evidence standard being applied, and sometimes that suspicion of something wrong or suspicion of that's not enough seems to be a grounds for denial, and more these days on all of the USCIS cases. So I'm not really sure if that answers your question about if this administration is the cause, but we are seeing more hoops that we need to go through, and then easier denials coming out of USCIS as a whole.
I've not seen it in 526s either, but the speed with which we've seen changes in other areas is cause for concern. Yeah, because it's gonna safe bet that it's going to, right? Just last week, I think it was, they terminated a policy memo of giving deference to prior approvals on H-1B visas and other types of work visas. So after a policy that was about 15 years old of giving deference to try to make things a bit more efficient, gone. Scheduling interviews for every employment-based green card case filed after March. Talk about a strain on the local immigration offices and on practitioners and people, right? So I think that you can tell what the environment is at the service and the path that it seems to be heading. And I don't really see a world in which EB-5 can stay outside of that. We're seeing it in all the other visa types and green cards, and we're seeing it at the consulate. We've not seen it at the Labor Department, at least I've not, with respect to okay, lucky me, I guess. But my point is that even though we're not now, we're only 10 months in. And I think that those changes are coming.
We have 3 more years to go. So as so we've seen, we are seeing more and more RFEs. Nima, Genevieve, I know you guys have seen one with the actual getting an RFE on accredited investors. Nima, you want to talk about accredited investors and what you've seen with that?
Let's let Genevieve start with that one.
Okay.
She has the issuer responsibility.
Well, we've just in the last maybe 2 weeks seen 1, maybe 2 RFEs basically saying, we note that you are a student and you were gifted this $500,000 for your investment. We also note that in your subscription booklet, you marked that you're an accredited investor. Please provide evidence to show your accredited status. So that, this is, there are all kinds of RFEs issued in error, but these are concerning to us for sure, because as an issuer, so long as we believe we have no reason to, we believe that the investor is providing accurate representations, and we have no reason to think otherwise, we operate based on we will accept those representations.
Do you think it's outside the purview, though, of we're sourcing $500,000, right? And of course we also have to source the administrative fee, so it could be $50,000. So we're sourcing that already. Is it now USCIS's should they be coming back and asking about whether or not the investor is also accredited, or should it be the regional center of the project who should be looking at that?
Well, I think I think it may be other agencies that would have an interest in that, but I certainly don't think that it should be really a part of the USCIS adjudication.
I don't see it either. I don't see the relationships with what we're trying to show to get a 526 approval. I don't see the relevance.
Yeah, it seems to me more of a securities
Yes.
questions, but
Exactly.
playing the devil's advocate here, I guess USCIS question would be, eligibility of the investor, of, where, if you are saying that you are one thing and you're not, it goes to a misrepresentation of oneself or another, and therefore the whole eligibility as an investor becomes an issue. Whether or not I agree with that is a completely different thing, but I think that may be where they are coming from.
Yeah, I mean, I think that's a good point, right? It's the same argument that they make with tax returns.
Yeah.
Because you didn't pay your taxes doesn't mean your money is unlawful, right? Because you mark accredited status and maybe you're not, that actually isn't a USCIS issue. We never provide the accredited investor worksheet. We also never provide the list of the other investors in the project. We don't want an RFE for accredited investor. We don't want an RFE for oversubscription. That has nothing to do with USCIS. That's an issuer responsibility. And even if you're not accredited, it becomes a personal liability, right? If there's a project failure, maybe you're not getting paid back. I don't know what that has to do with your money being lawful or not. I think in fairness to USCIS, you don't know what is an issue until you see the case. So you're just going to have a 2-year lead time. But at the same time, when you're an issuer, like Genevieve is or Extel is, I mean, you have securities implications here, right? I mean, you're on the hook for a substantial amount of money, and USCIS is changing the game on you in the middle. Ripple effects, big time.
Yeah. So we have other trends that we have been seeing. I'm going to go through them quickly because I know we are running out of time. But we've seen, we've had the third party currency swaps right now. So we're seeing, they're asking whether or not the person who's been helping with the transfer, if the funds have been, if they've earned the funds legally as well, or if they're actually from an accredited bank. So we've been seeing that. Genevieve, I know you said you've been seeing, whether or not our mortgage has been properly recorded, which we didn't have to see before. We didn't have to show that before.
Yeah, I haven't actually reviewed these. It's not our investors, but I understand there have been RFEs coming out asking if the mortgage has been recorded. If not, if it was the loan was paid off before the mortgage could be recorded. People are providing evidence of that, but I think a logical next step might be to ask, okay, how did you pay this off so quickly?
Yeah, and that's just taking it another step further. So others that we've seen are inconsistencies from if you filed, and I think Nima touched on this before, if you filed previous applications, and now they're looking at that, if you filed other visa applications before. So how much do we have to show as immigration attorneys? Do we have to source now our entire investor's immigration history? We're getting RFEs on it, so how far back do you go?
Yeah, this is an interesting one to me. Some of the one Noid in particular that we did a consult on, it was about the months and years in which the person's dad had terminated employment like 4 jobs ago. And he had indicated December 2000 on his DS-160 when he tried to apply for a B visa or whatever visa from the consulate. And then on the resume that was submitted as part of it, it was a month earlier in 2000. Noid. It was a series. I'm not going to understand. It was a few of those things, but still nothing that, in my view, would create a situation where that money was somehow therefore not proper. It was not from the sources that we said it was. So it's really interesting. We're seeing it in other non-EB5 contexts too, like sharing of information and database searches. that the government has access to and has had access to for years, but is now using it. And I say now, I don't mean Trump now. I mean now in like the past year or two.
Okay, so what I really want to get out there is that USCIS has been changing some of the policies or the way they do things midstream. And Genevieve, I want to get your opinion from being a regional center. You know, now that we had this issue back in 2015 when they came out with the indebtedness issue. Some clients were getting denied or you had to withdraw. Same thing happening here again with the third-party swaps, currency exchange. As a regional center, how does that affect you?
Yeah, I mean, going back to 2015 with that change, we had a few people that were approved, and then things changed. It was very clear that things were going to be different, and we had one investor who got an RFE, and we asked them to withdraw their application that was pending almost 2 years, rather than take a denial to protect our, and little did we know that those withdrawals are going to be recorded as denials.
Yeah.
Anyways.
Yep.
But now with the swap RFEs, it's a similar situation. We have had a couple people reach out. These are people with children who could age out, who have been pending almost 2 years, saying, can I withdraw and refile using a new source of funds because the third party who helped me with the swap is not willing to provide all this evidence. And that's really difficult for an issuer because that money is already in the project, and there may not be other sources of capital to return their original investment. We've got to use their new investment towards the eligible expenses. So it's a really, really difficult. It's terrible for both sides.
You know, the practitioners in this space are really smart. You know, if you give us promulgated regulations and some logic, we'll figure it out. What is upsetting to me is when you get an RFE for someone using a transfer house and they say, well, the transfer house in country A is not the same as country B. That money, we can't prove that money is the same because they're not the same entity. We can't approve this. That defies all logic in banking, right? If you go into a Wells Fargo in Colorado, you're not going to get your exact same dollars back if you go to the ATM in LA. That's the whole point of the banking system. So I don't know how I can respond to you besides saying, I think you're wrong. What do I do though? I don't have any evidence to prove you're an idiot, so you have to sue in federal court, and then you're costing your client X amount of dollars and X amount of time.
Well, I'm going to finish it up. If you guys have any last points you'd like to make.
I think, again, I feel like beating a dead horse here, but I think that, if we are given a clear guidance and say, from this point on, you shall do this, we're fine with that. But when the cases are being pending for 2 years now, and you're applying the policy that you say today, policy is this, and oh, by the way, the application you filed 2 years ago, we're going to apply it to that one as well, when we didn't know the policy has changed, that's really not fair. And it's not fair to the business that is relying on the funds. It is, it's not fair to the investor who has relied on, and it's not fair to the practitioner who relied on the certain direction that we were given for years' practice. So I think that if you are going to change something, change it proactively as opposed to retroactively.
Yeah, mine's going to be the same as what I started with. So for practitioners who are filing RFE responses or source of funds or responding to NOIDs or denials or federal court, it's the standard. It's all about the standard, which is not clear and convincing, and that standard shouldn't be applied, right? It's preponderance of the evidence. We've said it 100 times, but that to me is so important to remind the Immigration Service of that standard, which they've confirmed is just that. And that changes everything in my mind as to how you view the evidence that's handed to support the 526.
Genevieve?
Yeah, I encourage in RFE responses to really hone in on that point of what is the standard. My only other point is that if it's what we need is more clear guidelines for people that are filing, so that people can proceed on a path that they, that they can reasonably rely on. Will get them to that approval.
I would just echo Jenny's point that the standard is, excuse me, I almost died. The standard is approvable on the day it's filed. It's not approvable the day it's adjudicated. And if there's a 2-year lag, that's on USCIS.
Yeah, and my issue is the inconsistencies. It goes to all of this, but we get one RFE on this, and then another application with the exact same thing, and you're getting approval. So again, it's the educating the adjudicators and telling us exactly what is it that you would like to see from us. And that's it. Thank you all.
No questions.
Oh yeah, are there any questions?
No questions.
You should get that.
we were so good.
Mike?
Do we need to prove the source of the service fee?
The administrative fee? Yes.
Yes. No.
No.
If
Administrative
you
fee.
cannot do the legal source for administration fee, USCIS will take that amount from the principal and say that you didn't fully invest the full amount.
Yeah. Any other questions? Can you get the mic? We need last question.
But it used to be like that. Like you were in Africa, you didn't have to.
So I have a question. Say suppose if I want to sponsor a family or a friend who is in abroad, outside of the country. So is it mandated that he has to be a blood relative, or can it also be a pal?
Oh, you're talking about gifting,
Gifting?
money?
Yes.
Yeah. No, the USCIS has not said that there needs to be a familiar relationship. However, from what I am hearing from other practitioners is that, they would like to see some sort of nexus between parties as to why should someone, Rebecca can give me 500,000. Thank you.
I wish.
But, they're going to ask, what relationship do you have and why
With that
is it
person.
not a money laundering? So we're afraid that they may require that at some point, but they have not.
It has been in prior. They've mentioned it in prior bills, proposals,
Yeah.
that you have to have a familiar relationship,
But
a close familiar relationship. But at this time,
It is
like
not.
Jinhee said, you can gift to anyone as long as you have that nexus.
So my next question
Oh.
related to this is, say suppose if the project gets failed, I mean, for some reason.
Well, can we do this? I know because we're running out of time. Do you want to see us after?
You can just talk to
Thank
us.
you.
Thank you.
Started with the next panel. This will be an interesting one. It's titled No to the Wall, but Yes to Infrastructure and Redeployment in Bonds.
Thank you again, everybody. We have a wonderful panel today, very interesting topics, with a lot to say. So before we go any further, I'm going to ask each panel member to introduce themselves. And we'll start from that end. Jeff.
Hi there, Jeff Drinkwater with NES Financial. We're a part financial services, part technology company based in San Jose out in Silicon Valley. And we have a host of solutions to help developers and the investor mitigate risk.
Thank you. Richard.
I'm Richard Booth. I am the EB5 compliance officer with Signature Bank, a full-service commercial bank located here in New York City. We are actually the largest bank in the EB5 banking space, and the only one in the United States with a compliance officer for the EB5.
Thank you. Kyla?
Kyler James, Vice President and Chief Economist for CMB Regional Centers. Operate a collection of regional centers across the country with over 5,000 investors.
I'm Kate Kalmakov. I head the EB5 practice at Greenberg Traurig. Greenberg Traurig is the largest law firm in the United States, and we have one of the largest EB5 practices nationally.
Thanks, Kate. Julia?
My name is Julia Park. I'm the Managing Director of AAEB5 Group, Advantage America EB5 Group. We operate 6 regional centers in the United States. Mostly our projects are located in New York City.
Thank you. All right, so this panel is entitled No to the Wall, but Yes to Infrastructure and Redeployment with a question mark. So, no to the wall. What do we mean here? Kyla, I'm going to start with you. No to the wall.
Sure, absolutely. For me, you know, sort of the idea of the wall, when you look at EB5 especially over the last few years, what we've found is that projects are coming into this, investors are coming into these projects, doing the best that they can, obeying the rules as best as they can, and 2 years into it, oh, we're going to change the rules. We're going to adjust things. We're going to put up again, the wall. We're going to put up additional obstacles for you. We're going to create a scenario whereby you will fail. And redeployment's a great example. They've projects that were structured 4 years ago, fully funded 2 years ago, have investors currently in them, are now looking at this saying, well, we didn't envision this. How do we restructure? How do we avoid this new obstacle that's been created? And how do we move that forward?
Right. So what you're saying, Kyla, is that we are building a wall. We're proponents of pro-immigration, and yet we're building a wall.
Absolutely. At the end of the day, the program doesn't exist to stop immigration. The program exists to bring immigrants into this country, to create new American jobs within this country. One of the previous panels, one of my colleagues suggested the idea that nobody has really put together a good economic model that looks at the economic impacts of bringing these high net worth, entrepreneurially minded immigrants into the U.S. What a fantastic thing that we have, and yet for whatever reason we've created this scenario where we say let's stop immigration instead of act as the program for immigration services.
Yeah, but Kyla, don't you feel like the certain amount of compliances and a certain amount of rules are necessary?
Absolutely, and rules existed 2 years ago and 4 years ago, and those rules were obeyed, and now we're adding additional rules. We're adding additional obstacles.
And as a regional center, are you finding yourself, Julia, that banks are actually not helping, that they have too much compliance?
Of course not.
Well, Richard, you had the compliance. How are you making life harder for immigrants?
We are not making life harder for immigrants. We are making life safer for immigrants. We provide a very good framework for the EB5 space. Let's face the facts. The EB5 program has matured, and the numbers are larger than they ever have been. And compliance should be welcomed to ensure the survival of the program. We welcome the integrity provisions. We are a bank. It's in our DNA. And regional centers who are fighting the integrity provisions really should take a step back and look at the business that they're in. I mean, you're dealing with millions of dollars. And, these are things that banks, routinely deal with on a daily basis. We work with many regional centers across the country, and I've met with compliance officers of all across the U.S. And I'm always very happy to share what we do at Signature Bank in terms of the framework. We have built out robust compliance measures that go from a process assessment to a risk assessment. We have regulators that routinely look at our program. Matter of fact, we have 6 regulators in-house now from the FDIC that are going through the program as we speak. I have met with them on numerous occasions, explaining the intricacies of bringing investors in from China, bringing investors in from the Middle East. And, we have done a very good job in terms of meeting what they expect.
Sorry, Richard, how much of the market share do you have? Does Signature Bank have of the EB5 market share, that is?
I don't know the exact percentage of that, but I know that we are if not the largest player, one of the largest players in the EB5 space. Somewhere north of about $16.5 billion in escrow.
That is a fair amount. Do you just accept any project into escrow, or do you have rules?
Absolutely not. We are very picky and choosy of the projects that we have in house, and that started long before I got there, and with our group director. But it was built out after my arrival at the bank as the dedicated compliance officer. And I'll just take a step back real quick. Fully understand my role at the bank, I report directly to the chief compliance officer. However, it was the group director at the program within the EB5 space who was the genesis of bringing myself on board, because he realized that the program was getting so big and realized that it needed to have an independent set of eyes looking at what's going on in this EB5 space.
Okay, thank you. Well, Kyla, you mentioned redeployment. Kate, what is redeployment for people who may not understand?
Sure.
Big
so
term.
redeployment is the concept of reusing the EB5 funds once they have been used for the EB5 purpose as described in the business plan and the PPM. And it's a relatively new concept that has arisen in the last year or two, because the wait line for China has grown so long that right now it's 10, 12 years for a green card. And according to the rules, funds can't be returned any earlier than, filing of the 829 petition. So if funds can't be returned, then they have to be used. And recently, USCIS issued new guidance with respect to redeployment, saying you must redeploy. So whereas before we may have held funds at the JCE level, which is your job creating enterprise or your project, now you have to redirect funds. You can't just hold them in an operating account. You were never permitted to redirect them back to the fund account where the investors are, limited partners or limited liability members, because then they wouldn't be considered to fulfill the at-risk part of the regulation.
Kate, it's not law yet, though. It's just a proposal.
That's right. It's just a proposal, but it causes, a lot of questions to come into play. First, what do we do, there's different models of regional centers. So where we have a developer-owned regional center that is using EB5 as financing for their developments, they presumably have a pipeline of projects, though not all may, and it's easy for them to redeploy. What do we do with the regional centers, though, however, that are structured to act as lenders that may not have another project right now? How would they redeploy? And if you're forced to redeploy, how do we safeguard investors' funds? Are we willy-nilly investing into any project because we have to stick funds somewhere? And so now what we're seeing in the market in response to this is the creation of different fund models where you can redirect funds and then they will choose different projects in which to invest them. But, USCIS, of course, hasn't adjudicated that either.
Right. Well, there's a lot of us practitioners who have argued against the redeployment rules as they are today, and I think the first thing we could argue is that redeployment is not necessary because your funds do not have to be, by law, kept at risk at the I-29 stage. Julia?
So It's the big wave. China market is dying. New funds, there's going to be a limited amount of funds coming in. The reality is there's billions and billions of Chinese investment already in the United States that's going to mature in the coming years. So the question really becomes what happens to those funds. It's a we can look at this question legally in two different ways. There is an at-risk requirement that people are talking about. EB5 funds to be at risk in the beginning of the process, in the I-526 process.
But not at the 829.
Not at the I-829 process. At the I-829 process, the only requirement is that the funds have been sustained. But that's also a little tricky because when we say the funds, when we look at the language of the regulation, it says that the funds have to be sustained during the conditional residency period, which is a 2-year period following the approval of the I-526 in a normal circumstance. Now, with the backlog of Chinese visas and the future backlog of Vietnamese, and then in about 3 years, the Indian visa, if we look at just China, there is this 8 to 10 year gap between the approval of the I-526 and the beginning of the conditional residency period. So we have to ask the question, was the legislative intent when they said the funds had to be sustained during the conditional residency, did they really mean 2 years?
Well, I think also that we have to remember that when legislation was written many years ago, it took 2 months to get your 526, not 2 years.
And there's also a very real securities concern here that is just not being addressed. Because this wasn't in the original offering document, the investor never saw this as a risk when they agreed to the terms of the private placement memorandum. So if you then send a supplement saying, according to CIS guidance, we must now redeploy, that investor is going to have a right of rescission, which in turn will jeopardize their immigration, which they may not want to. So it's really putting them in a very unfair position, and that securities aspect is not being looked at all by USCIS.
I agree. Jeff, you have, I know NES, I haven't forgotten you, don't worry. I know NES really do have a whole program for redeployment. Have you thought of all of these issues?
Yeah, so what we did, we saw this coming a while ago.
Can you speak close to your mic?
Yeah, sorry. So we work with probably close to 600 projects and 20 billion in targeted capital. So we saw this coming down the road. So what we did is partnered with a company called Capital United. So they're a registered investment advisor. They're objective in this process, and that's a big part of this. Is if you're a GP or a member of that NCE, you need to be objective and look at this not just as a developer saying, "Great, free capital here. I'm going to redeploy it into my next project." So this platform, what they designed is a couple different options. One of them, as an example, is Greystone. Gives you the flexibility where CapU looks at it, gives an opinion, and then recommends what you should do with that redeployment money. And,
Yeah, but
it gives you liquidity within that, where you can actually customize it to each investor of when their conditional residency is coming due.
But does the investor have any say as to what you do with their money?
Well, that's, again, they should, right?
Well,
And
do
that's,
they?
they actually should have to sign a consent form of where it's going.
All right, so you give your investors a consent form. Do you give them choices?
Again, CapU does. They give the NCE the choices, and then the NCE will ultimately make that decision. But the NCE needs to show that they're objective in this process.
Kate, you have an issue with that?
I have to think it through. I don't necessarily have an issue. I'm good friends with NES.
We all are.
I'm just thinking about the securities compliance concerns. So I think besides a consent form, you'd have to have material disclosures in the form of a supplement included so that they can determine if that's truly where they redeploy. And then what if they choose not to redeploy? What happens to that fund if you don't have unanimous consent?
Kyla, do CMB is exercise the right of redeployment?
Sure, and frankly, when we talk about redeployment, and this being a new thing, CMB has structured all of our partnerships from the beginning that there was a capability of the general partner to have those funds redeployed. Obviously, that comes with its own level of scrutiny and its own level of information that has to be provided to the limited partners, but certainly in any of this, it really comes down to a simple question: who's your daddy, right? The SEC has certain rules, the USCIS has certain rules. when those rules do not play fairly, when those rules do not comply with each other, what rule do you have to obey?
And that's a great question because CIS previously said we're going to cooperate with the SEC more. When we issue guidance or when we change policy positions, we're going to do it in consultation with the SEC. But in fact, there's no indication that that is happening.
I mean, basically there's this legal reality. I'm part of reality too, so how am I? But I'd like to propose a solution because this keeps going. This is a big topic, by the way, guys. Every single EB5 conference.
Before you do propose a solution, Julie, because I was going to ask that question of all, my issue is fine. If you have a project NES are covering and they're doing the right thing, CMB are doing the right thing, even in case some of your clients are asking you and doing the right thing, what about all those smaller projects?
Mona, all.
What about all of those? What about those projects where they really don't have guidance and they just know they're allowed to redeploy? Aren't we asking for fraud?
Yeah, I would say that's the biggest conflict of interest right now as a developer sitting with a redeployment option. What do you think they're going to do? A developer that's sitting on $20 million that they're getting back, they're going to plow it right back into their next project. And you want to talk about consent? Where's the consent there?
Right.
They're taking now 2 bites of the apple at risk. They didn't sign up for that. They signed up for a green card for 5 years of risk, not 10, not 2 different projects.
That's right. Richard?
We are all about disclosure. We feel that if you're investing in a project and you're going through redeployment, it needs to be spelled out clearly and very forthright in the original documents, and the investor has to be able to make the choice. Because if they don't make the choice, then it's at the end of the day, it's their money, and they should have the ultimate decision where it goes. And I agree with Jeff that taking 2 bites at the apple, with the same developer, you could run some serious risks with that. And I don't think the developer or the investor really saw this coming down the road when they originally signed up, unless it was fully disclosed.
And that's very different than the current situation because now when you structure, any project right now, you're working redeployment into the documents. But even then, you're in a bit of a bind because we can't list a specific project where the funds will be redeployed to. We can list categories. But what if they don't materialize? Because, real estate is a fluid thing. An opportunity today may not exist tomorrow. And what do we do with these funds? In what time periods do they need to be redeployed? None of this is clear in the...
Well, that is, Kate, if they're being redeployed within real estate. If it's a project which has their own, it's a developer project, they will redeploy it within their own project. And they don't even have to show it's redeployment.
If they have one coming up, right?
Well, they could technically keep the money forever and just call it redeployment.
And then we will also run into the issue, what if today I have a project in New York and my next one is in LA? Is that permissible under the guidance? What are the limitations?
Right.
Not clear.
So... solutions.
Solution. We understand that the USCIS is limited by the language of the laws and the regs do say that the investment has to be sustained during the conditional residency period. So it's not the USCIS's fault that this is becoming a problem because, for better or for worse, that is how the language is written. Where the USCIS can make a difference is the fact that they're applying the at-risk requirement at the I-829 level as a matter of policy. This is something the USCIS has control over.
Right.
And if we shift that policy, the funds can be kept in a more secure operating account, as people used to do when timing did run over. It's now that we're being forced to put this money at risk. And this is a policy position, which I think we can fix.
Right. And I think there was a fear at one point when the draft regulations came out, that could these funds from redeployment be put into some kind of infrastructure project, aka the wall? No comments?
IKEA had some good instructions. I don't know if you guys saw that.
I think we saw a lot of different proposals in this respect because I think infrastructure is really a priority of this administration, or so they have stated.
Right. That's where I was going to.
There was a little bit of a bouncing around of introduction of an EB6 program where you can invest at perhaps a lower amount, but it would be used towards infrastructure and the wait lines wouldn't appear. That didn't move forward. And in talk of the proposed legislation, we have certainly seen this proposal of a set-aside towards infrastructure also introduced.
Right. I mean, the idea of putting redeployment money towards the wall is not something that we just dreamed up. It was the EB6 proposal which brought that to the forefront.
But even besides the wall, just in terms of finding financing for infrastructure is very difficult in this country. So there are many legislators that have pushed for that to be introduced into the new bill as a way to, finance our crumbling infrastructure.
All right, but this money also is very cheap money because the original money that was brought in had a cost to the developer. So does a developer feel that he has a right to keep this money because he's already spent X amount of money getting the money in the first place?
Yeah, and he doesn't have to pay the agent.
That's right, exactly.
So this is great newfound money to them, and it's unfortunate because the investor on the first go-around gets, 0.25%, let's call it. And now on this go-around, what does he get? I've heard varying amounts up to 2% or so in some new deals. But ultimately, the developer's looking at this as really cheap financing. Thank you, Heidi.
So if Julia, if we don't succeed in convincing USCIS that the money is not at risk, do you have any other solution for redeployment purposes?
Well, I think there's a cottage industry already popping up with these redeployment solutions. And I'm a realist and a practical person. We are looking into that. We're looking into creating our own redeployment solution with other partners, for example. So this, unless we have some clear guidance in the coming years, this is going to be a whole new industry, which is not necessarily a bad thing. The only people losing out on this are the investors, really.
Right, but how would the panel feel if, when it comes to redeployment, it's not USCIS that actually adjudicate, but perhaps another government body, something like the Chamber of Commerce? Kate.
That would be interesting. We've had before proposals to involve the Department of Commerce in EB5 adjudications, and they've never materialized. I don't know because I haven't dealt with commerce, what it's like to deal with them, but, presumably they would understand, some of the financial aspects of transactions more than USCIS.
Right. Kyla?
My one concern, again, would be you're just inserting another body into this to take a look at this and answer another set of questions, again, further on in the game at this point, after you've already established that you've met all of the requirements of USCIS.
But wouldn't you be inserting a body who had more specialized knowledge?
Certainly, as you do with securities in the SEC.
But that doesn't have knowledge of all the nuances here related to the reinvestment and, requirements of sustainment. So what's the learning curve? What would we see in terms of adjudication?
Right, and I think also given the varied amount of different types of projects, that probably would be a longer learning curve.
Yeah, I think that the challenging part here is that our clients are asking for more clarity from the USCIS. That's the one thing. We talk to them about these different options that they have through this platform, and they are at a standstill, and they're waiting. And one of the things I always hear is, thankfully, I don't have to redeploy for another year. All these other people in front of me are going to learn the hard lessons of what I'm going to need to do. And I think that's unfortunate for these folks that do have to redeploy sooner than later. And again, that's why our platform, we think, helps give them the flexibility of liquidity, preservation of capital, transparency, and some yield.
Yeah, but Kate, I don't know if you've actually seen this. We have got clients who've managed to, prior to the 829 approval, maybe they've had a hotel or a senior assisted living home, and they've sold their senior assisted living home or their hotel, and the 829s have still been adjudicated and approved.
Yeah, and I see nothing wrong with that scenario. I think as long as the funds don't flow back up to the new commercial enterprise, you're fine.
Well, I'd even go further than that. We have had funds flow back up to the new commercial enterprise and be redeployed from the new commercial enterprise at the discretion of the general partner, so that it's not a controlled by limited partner scenario.
So the bottom line for redeployment, Julia?
I think we need to rethink the current policy. Outside of that, only the investors are at risk.
Kate?
I agree. I think mandating redeployment as opposed to keeping funds at a JCE level is concerning, or another operating account where, they're at risk of loss.
If I can add in there, the concept of disclosure, we've talked a lot about that being an upfront necessity for any of this, and yet USCIS has failed to disclose in a lot of this. USCIS has failed to give us the upfront information that would be necessary in order for us as regional centers, us as attorneys, and again, the most important people at the end of the day, the immigrant investors, to know the risks associated with this from day one.
Well, I think they have given us information. They've told us what they want to do, and that is redeploy.
If that was the extent of the information I was giving in my disclosures, though, I would be in serious securities concerns would be present there. So it has to be more than simply, we want you to do this.
Right, but most PPMs do have a clause which protects the developer and the project owner against changes in the law and policy changes.
Again, most vulnerable person in any of this is immigrant investor.
Right.
Absolutely.
Richard?
It's the common thread throughout this panel and also with the other panels is that we need from the USCIS clear and concise guidance, and what we're getting is as clear as mud, and it can't exist. You're dealing with it's an immigrant investor program. It's here to help people come to the United States who are going to invest a significant sum of money. And you're dealing with bankers and you're dealing with attorneys who in their trade are used to dealing with black and white. And until we get that from the organization that is supposedly overseeing this program, it's going to be, we're going to continue to sort of bump along down the road. So again, we need clear and concise guidance so we can communicate that to our clients, whether it's a bank or an attorney.
Yeah, my comment would be like waiting for USCIS for more clarity is going to be like waiting for Trump to stay off of Twitter. It's not happening. So absent of that, we need to do what's right by the investor. We have an opportunity here, which we haven't done in the past in this industry, is to do right by the investor.
Right. Well, I've given my opinion that I'm very against redeployment the way it stands. I think it's fraught with difficulties. But redeployment isn't just one area that we're building a wall. Julia, we have other areas where they're building a wall.
Are we talking about bridge financing now?
We are.
Okay. So
that was your cue.
This is fairly new. Let me just give you a 3-minute background on bridge financing. It's really relevant in real estate projects, for better or for worse. I think Mona said earlier that real estate has somehow hijacked EB5. Real estate is a big part of EB5. Real estate in metropolitan areas, mostly New York City, for example, EB5 is used as mezzanine financing. That for non-real estate people is positioned between the developer's equity, there's the EB5, and there's the senior bank loan. Now, what happened before 2013 was the USCIS required a clear nexus between the money and the job creation. So if a developer used bridge financing to proceed with the project and then later used EB5 to replace that bridge financing, the USCIS did not allow this. There was a policy shift over the years that we kind of felt in the air, but it was articulated in 2013 in the May 30 guidance memo, where the USCIS came out and said bridge finance, EB5 funds can be used to replace bridge financing if bridge financing was contemplated prior to the raise of the EB5 or the bridge financing was temporary. Yeah. Now, what is temporary? Anything expensive? We don't know what's temporary. Now, the problem here is that we are now seeing the pendulum shifting back, and this is very recent, I think past 3 to 6 months. Yeah. We are seeing a trickling of RFEs coming out of the USCIS questioning EB5 funds being used to replace bridge financing, and we're hearing things like, well, temporary means under 1 year. Some people have pushed back and said, well, it was if it was contemplated, since it's an or, contemplated or temporary, then shouldn't it be okay? The USCIS has not really talked about it until Tuesday of this week, where there was a stakeholders conference where the USCIS economists stated that we don't believe that was meant to be A or B, so even if it was contemplated, that could be a problem. Now, here's where this is becoming a problem. in real estate financing, the bank, which takes up about 70% of the capital stack, will not come in until all the other money is already there. So if we are not allowed to bridge EB5 financing, we can't secure bank financing. So in order to secure bank financing, you have to have the developer's equity and the EB5 bridged. In September of 2015, the USCIS has started putting out RFEs asking projects to show that senior financing is secured. So now we have these two different
which contradicts
pushes.
each other.
Contradicts
Yes.
each other in that they want us to secure bridge senior financing, which means we have to get a bridge unless the EB5 financing is going like 10 investors a day.
Which by the very nature of EB5 doesn't.
Is not happening. And because the China marketplace is slowing down, the speed of financing EB5 is slowing down as well. So now we're kind of stuck in the middle. You're basically saying that if bridge financing can only be for a year, but we have to secure senior financing, all EB5 raises by definition then must be raised within a year. And then we also have the weird incentive of if your project is really, really delayed, so when you get that RFE, nothing has happened, you're actually okay because you haven't gone out and gotten your bridge financing yet. So we're in a difficult situation and we need a little bit of clarity here.
All right, Kate.
Well, I mean, I think it's a huge problem. I think procedurally, immigration is probably going to end up in court on this because, you know, they issued binding policy guidance in 2013 after having notice and comment period. Here, they issued new policy guidance this year. There was no notice and comment period, and they basically changed this policy on bridge loans. And it impacts projects that were filed before this was implemented. So you have an issue of, you know, changing the rules retroactively. In terms of what they're doing, it's very problematic because I don't think a bridge loan is defined as 1 year. I don't think that's what it is in the real estate industry. And our friends from the bank can also comment on this. So if we're getting these types of noise, I think you have to include a letter from a real estate lawyer, from a bank, confirming how they define a bridge. And, you know, prior to this, CIS approved, we had one deal where we went back 5 years where we could show intent to use EB5 and say that equity was contributed in contemplation that it would be taken out with EB5 and it was to be considered a bridge, and that was approved. So imposing this requirement is really not fair, and it's also arbitrary.
And capricious. You have to use the full legal language. Kyla?
No, for me, the idea of bridge financing, if nothing else, I feel that USCIS with a combination of a few other things, is really encouraging those poor projects, those projects that are likely to find delays. That they're doing this both with the idea of this bridge financing, that if you find yourself later on and you haven't actually inserted the bridge financing, you haven't moved forward, and you're getting the RFE, you're better off. Well, those are indications from a project due diligence and underwriting standpoint that cause great concern at that point. When you couple that with the idea of you have to have your senior financing in place at this point. USCIS has come back several times and with some of our projects and said you only showed a term sheet, show additional information to prove that the project is ready. Those are indications that a project should be moving, should be damn near complete by the time that you have an RFE.
But I think that's where the issue really is, Kyla, is that actual real life and business and immigration rules. There's a huge disconnect.
Certainly.
Mm-hmm. Richard?
You know, my group does a lot of bridge financing, and when they start talking about terms of bridge financing, how long is it? What's the time spent? The time breadth of it? You really can't put a number on it. It depends on the individual project and on the individual client. So for an organization to come out and saying it's going to last for so many months or a year or whatever, it's totally disingenuous. Every project is unique, and every need for bridge financing is unique. And some last 6 months, some could go on as long as 3 or 4 years. And so again, it's for them to put a specific number on it is not the way to go.
Richard, but bridge financing isn't cheap, though. I know your bank has quite high charges when it comes to bridge financing.
Yes, it's not inexpensive, but again, it's a tool to get between 2 points, and it's used in very unique circumstances, and it helps get projects off the ground. So again, it's something that we do offer to our clients, and we are proud to be able to offer it.
Yeah, Bona, I would just add going forward for people that are doing projects, I think when you get in terms of bridge, the way EB5 should be used is to knock out bridge, and it eliminates that risk of the project actually being completed.
I think to that end, one sort of strategy that you can use in structuring new applications, because we're defining terms in an artificial world, is any equity that's put in, we can define that as a short-term bridge and then bring in EB5 to take that out, so that we can work in sort of some kind of flexibility and have a strategy to get the EB5 funds in outside of this limitation. I'd like to point out one other problem with this policy is that now they're requiring that any bridge money that comes in, it has to flow through the job creating exercise entity. So before, you could, simply pay off the bridge with the EB5 funds. It didn't have to flow through the JCE. Now it does. And that, of course, is also problematic because that doesn't really always work in the real world.
Yeah. Julie, you had a comment?
I did. I was blanking out. Yes, but because of what Kate was just talking about, this was also discussed on Tuesday. But I would like to point out that this is not a full-blown tenant occupancy situation. What I mean is there are certain areas in EB5 where the USCIS one day says, we're not doing this anymore, or we're changing this, and it just affects everybody like a tsunami. Tenant occupancy was one of those things many years ago. On the source of funds side, last year, the whole indebtedness issue, they one day said, we had a stakeholders call, we're not allowing this anymore. The bridge financing thing, we're still in the initial stages. We're only hearing about a few handful of these NOIDs and RFEs, people pushing back. The USCIS articulated its position a little bit on Tuesday during the stakeholders call. I don't think we need to call this a policy yet. They're pushing back a little bit, and we're in dialogue, I think, through these events.
I think also there has to be a little guidance as to the amount of time you can keep bridge financing. I totally agree. I don't agree that it's 1 year, but I do think there has to be you can't
parameters.
Right, some parameters, because some people or some projects just totally
May
misuse
30
this.
memo was very open-ended. It was inviting people to do fully funded projects and just kind of refinance. There were problems.
But the May 30 memo also recognized the business necessity of requiring some kind of bridge funding, as well as the fact that EB5 takes time to bring in.
Mm-hmm.
Wasn't that solved with early withdrawals?
Can you speak on the mic, please?
Guess we'll go to questions.
That's okay, Chaim. We were just waiting for your comment. Nope.
Now,
Yes.
I thought we solved the issue of bridge financing through early withdrawals.
Of
You
the
have
early
this,
release of the
especially
escrow.
for Signature Bank, you have plenty of money in your escrow accounts, so you're providing bridge financing with the money that you already have in your bank. Why is it more expensive? But that's a separate issue. I thought the problem was solved, the bridge financing, by allowing, and USCIS is 100% behind it, early withdrawals from the escrow account. Now almost 100% of the funds is withdrawn upon submitting of the I-526 petition. Why is this still an issue?
Because I think fundraising has slowed down, Chaim. Getting funds out of China used to take no time at all, and now it's regularly taking even the largest agents we work with 3-4 months per applicant just to wire the funds out because of the restrictions that were introduced in July.
Understand, but the bridge financing has begun only because it took so much time to get the petition approved.
Yes, you're correct.
Right.
So once it's in the escrow, and it pops out within 2 months after it being in escrow, upon submitting a I-526. I understand the issue is still there, but a lot of it has been solved.
No.
And the problem, I didn't. And the problem with China is not a real problem. The problem with China is that most of regional centers are chasing EB5 investors in large cities in China using the largest migration agents. Pessimism seeks in. Why don't we go to second and third and fourth tier cities in China where people do not have a clue what EB5 is, and yet they still want to come to America? They still call America in China Mei Guo, the beautiful land, in spite of what's happening in the White House.
You can't paint that whole solving of the bridge financing with the early release with the same brushstroke, because every deal is unique. And the release provisions are different for every deal. So to say that bridge finance or early releases were going to solve the bridge financing issue is not correct. It's
But then we should write the early release provisions similar in every project, the same.
Well, you can't. You can't. Yeah.
You can have no market advantage
And
here.
it also doesn't help the projects that are already pending months and months. That relied on guidance that was then changed sua sponte.
Complicated.
It's a complicated
Absolutely.
business.
Absolutely.
That's why it's interesting, I guess.
So do we have, we don't have too much time left, and we don't want to encroach into the time that we're waiting to hear the golden pearls of wisdom from USCIS. Payman, you have a question?
Is it question time?
It's question time.
Okay,
Chaim kind of started the question time.
Very good. Thank you.
That's okay.
Well, I guess this is going to be a litigator's bonanza coming up, and I'm referring mainly to the redeployment. But before, I was going to just float something that maybe the panel could address. But just one thing I wanted to kind of point out in terms of, I guess, from an investment industry's perspective. When the funds are raised for the first project, the general partner of the NCE is basically acting in a non-discretionary authority, right? So the investor is picking the actual project. They do the due diligence. They look at whatever the financials are. The investor consents to make that investment in that particular project, and the investment is made. And the general partner, of course, then manages that investment. But after that, if we go into redeployment, the general partner can say anything in the operating agreement that they do whatever they want with the money, but now they have a discretionary authority, right? They are choosing on behalf of the investors to make an investment. So now we start getting into thin ice as far as the securities laws are concerned, right? Because they are acting as a manager of a blind pool. So that's something that obviously needs to be taken into consideration. I'm sure it doesn't apply in all cases, but in many, we are now getting into securities laws. But with regarding to solutions, and I agree with the panel that redeployment should not be a necessity, that's for sure. But for now, I also agree that we have it, and therefore we have to come up with solutions for it. So really what I want to kind of talk about, or for the panel to give comments, is that fiduciary obligation of the GP to the investors, right? So redeployment is going to happen whether it has to be in another project, whether it has to be into a third party's project, whether it is into a fund. That fiduciary responsibility now comes in to actually act on the investor's best interest. So immigration matters aside, we're now talking about investment, which really ought to be at market returns, right? The first one may have been done at 0.25% return to the investor, but the subsequent investments, really, it's not in the best interest of the investor to be made at below market investments. And that goes to whether it's another project, whether it's another fund. So the obligation becomes to find an appropriate investment vehicle or investment project that returns, provides a market return to the investors. and therefore the fiduciary obligation. So do you have any comments on that?
I think, Payman, what you're trying to say is something that would be there in an ideal world. I think what we are trying to speak about is that in the ideal world doesn't really exist, and but for a handful of good projects and regional centres, etc. No, joking aside, the issue really is here that how do we prevent misuse of redeployment? Because the redeployment rules as they came out in the proposal are fraught with difficulties, and I think the rest of the panel agree.
Yeah, opaque.
To say the least.
We would all love to know.
Yes.
No other comment too? No. Right, any other questions? Really? Professor? No? All right, so we'll just end with a couple of closing remarks. EB5 is being challenged right now, and I know if I say to each of the panel members, what would you like to see as a solution to the challenge, they're all going to say visa numbers. But other than additional visa numbers, if I can start at the end, Jeff, what would you like to see? If you had a little magic wand and you could wish for anything.
It's consistent with a lot of the other panels. Is just more clarity from the USCIS, more consistency.
Richard?
I'd like to see some good integrity measures, be brought forth in this new legislation. But I'd also like to see it clarified. I don't want any kind of fuzzy, clarity provisions that are going to cause more confusion for all the players in this space. Again, it's there's some very good templates out there, both with FINRA and the other regulators that they could lean on. And I think that if they work closely, if everybody here in the industry reaches out to their elected officials and to the regulators and explains exactly what they need. We are the experts. The folks in Washington are not, and nobody knows the business better than we do. So I think that again, if we get clear and concise, provisions on the integrity, it will raise the bar for all the players, and we will have a better program to go forth with in the future.
Kyla.
It's really the idea of TEA, investment levels, more visas, all of that. Absolutely.
If you had one wish, Kyla, you can't have three.
Life would be my wish. Give us a long-term extension to the program. That's really what is killing the program at the end of the day, is the fact that we are all stopping and starting over and over and over again every 4 months.
Kate?
I also have a long list, Mona. But I guess it's a consistency in adjudication and a decrease in processing times, because I think that's really adversely impacting and frankly turning many people away from this program as compared to the European programs.
All right. Julia?
So the USCIS holds periodic EB5 stakeholder meetings, and they're mostly through teleconference and usually held in Washington, D.C. And earlier this week, they held the first one in New York. And after many, many years of listening to the stakeholders conferences over the phone, I attended in person for the first time. And I was very struck by something while I was there that I had never realized when I was just doing it over the phone, is that the people at the USCIS care more than I gave them credit for. And you could feel that they were very constrained within the language of the law as well. It wasn't as arbitrary, as capricious as I think to myself while I'm driving. How can they do that? They are confined by the law and the regulations. So my wish is that if they could engage with us more, to work with us in areas where they are not confined, where the USCIS does have the discretion to work with us on policy areas, so that we can all achieve the same goal, which is the success of this project, program.
Yeah, I think, Kate, Julia, you know, being lawyers as well, you would agree with me that in almost all immigration areas, there is an element of discretion available to USCIS, which they really need to be able to use more in EB5, because there are so many elements where there is the strict area of the law and strict business, and then we're dealing with real life, real people, real time stuff. So I think if we had the ability to have discretion used a little more for cases where, okay, we understand the rules are not what they should be for that particular example, but if the rules could be bent on the grounds of discretion, I think I would be happy. You agree? All right. Well, I want to thank my panel, and I want to thank you as a good non-asking question audience. Thank you. Thank you. I want to give everybody give a big hand to this amazing outreach that we are receiving from USCIS. I asked for it before you started talking. No, joking. So I don't think that I'll ask them, they don't need any introduction, but we do have...
I can introduce myself and the team if that's easiest.
That would be wonderful, Julia.
Okay.
Thank you very much.
Yes, thank you. All right. Thank you very much, everyone. We are super excited to be here. I think this is the first time ever I know it's the first time IPO has done YouTube Live. So we have just bolted into the 21st century. That's exciting. So my name is Julia Harris. I'm the acting chief of the Investor Program Office, USCIS. I have John Lyons, a senior economist, or senior advisor for economics with the Investor Program Office, and Ricky Murray, who's our division chief for one of our operational teams that adjudicates the I-526. And also, Ricky recently moved to that team from heading up our policy team under Lori McKenzie, whom I'm sure some of you recognize her name. We are so grateful to be invited to speak with all of you at this event. We're going to do this for those of you who were with us on Tuesday. I know I see some faces in the room today that I saw on Tuesday at our stakeholder engagement. We're going to do this a little bit different. We are taking advantage of the fact that this YouTube is also being captured and being broadcast in China, and we're going to share some kind of general information about the EB-5 program to all of the thousands of viewers in China who might still be wanting to know some of the basics of the EB-5 program. And then once we're going to have John do that because he does such a great job at it. And then we're going to do some Q&A. And during the Q&A, we have not been here with you all day, but it was YouTube Live. So we did sit at lunch and watch some of these panels. We did. And so we were like, they're talking about some really interesting things. We'd like to hear a little bit more about that. You guys posed a lot of interesting questions. And some of you even proposed solutions at your panel. So if you are thinking about asking us a question, something that we have never answered before, chances are good we are not going to answer it for you here today. But we would really like to hear your thoughts, because that's one of the reasons that we come out into the community. We get on our national stakeholder events, there's 600 people on the phone. We're not going to hear everyone's thoughts. There's just not going to be time, which is why we have made a concerted effort to get out into the local communities and do smaller events like this so that we have an opportunity to hear a little bit more from some of you. So if you have some thoughts about things that we could be doing to make this program more transparent, easier, more fair, whatever your thoughts are. We're not going to necessarily commit to anything today, but boy, hearing your ideas sure gives us some things to think about and take back to the office and have some discussions with our policy team and our council team, and it's just really great for us. We want to know what you guys are thinking. So when we get to the question and answer session, sure, ask your questions, and also tell us your thoughts. And I think that'll be a great use of our time here today. I have one last little thing to say. I see cameras, which I'm all about a camera. That's great. But if there's a camera, that means there might be press, and that's fine, but this is not a press event. If you are press and you have questions, we do have a press office at USCIS. I do not know the number, but you will find it on our website if you need to talk to somebody in our press office. All right, I am going to go ahead and turn this over to Mr. John Lyons. He's going to give you guys some great foundational information, and then Ricky and John and I will be back to answer questions and hear your thoughts. Thanks.
We were a little unsure as to what to present. Quite obviously, there are things like the proposed regulatory changes or proposals that may be coming from Congress which are yet undetermined. So those things we can't discuss. But when we found out that this event is being televised, not televised, but sent via YouTube and carried on some Chinese channels, we thought it might be interesting for potential investors and to understand what it is about the EB-5 program that compels so much interest. So I'm going to try to go through that today. I apologize if this is basic, but it is very basic. I have been advised by my counsel that I should not tell any jokes, not necessarily, not necessarily because it's inappropriate, but because they're not funny. Let's start with the first slide. Do I have the... These are the kind of topics we're going to cover today, which are very basic. What is EB5? What are the two pathways? What are the requirements for participation? The regional center structures, the motivations for investors and businesses, and a little talk about some issues at the end which may interest you. In particular, that about program integrity and about the use of capital in the United States. All right, EB5. As I think everyone knows, there are many categories of immigration to the United States. There's family-based immigration, of course, there are refugee and asylees, and then there's employment-based immigration, which we are a part of. Those who are seeking immigration to the United States based on employment are admitted because of their particular skill or their particular ability or profession. There are categories of this that apply to Nobel Prize-winning scientists. There are parts that apply to physicians coming to the United States. And EB5 applies to immigrant investors who are willing to make a minimum capital investment in the United States that will benefit the United States and explicitly that will create jobs. There are two pathways to lawful permanent residence in the United States. One is the standalone program, where an individual investor will come in and own or operate their own business, and the other is investment through a regional center. This takes us to the program origins. Back in 1990, Congress authorized this program as a category that provided for what we call the standalone investment. In 1992, Congress authorized the Immigration Investor Pilot Program, and they finally, I think, a couple of years ago, took the word pilot out of the name of our program. But that's what we now know as the Regional Center Program. And together, the standalone pathway and the Regional Center Program are commonly referred to as the EB5 program or the Immigrant Investor Program. The two pathways to seeking lawful permanent residence in the United States have some similarities. The investment amount, for example. The minimum investment amount for an investor is $1 million. If the investment is in an area of high unemployment, 150% of the national average, or if it's in a rural area, areas that traditionally don't have access to capital markets, then that investment amount, the minimum investment amount, is lowered to $500,000. The immigrant investor must make an equity investment in a single new commercial enterprise. The investment be at risk. There must be the chance for gain. There must be a chance of loss. And, most importantly, it must create or preserve a minimum of 10 jobs for each immigrant investor. The differences are largely in the mechanisms of job creation that can satisfy the immigration requirements. For the standalone business, it's direct jobs per investor. You can think about this in terms of the people on your payroll. The regional center model, which is undoubtedly the most popular model, and I think takes close to 98% of our petitioners, allows an immigrant investor to claim jobs from direct, indirect, and induced sources. Direct jobs, of course, are those who are directly involved with the production. The indirect and induced come from the spending on the job that create newer jobs at the suppliers of goods and services for that business. The direct, indirect, and induced jobs are calculated generally through economic models called input-output models. And That's also an ease for an investor. An investor going through the regional center system and the regional center itself to prove the job claim at the end, if the jobs were resulting from the investment of X amount of dollars, and the multiplier or the algorithm of the model showed that the expenditure of X amount of dollars would create so many jobs, all the regional center need provide is adequate evidence that the expenditure, the input into the model, was actually expended. So it's a tremendous advantage in that respect. Now, the process for immigrant investors. The first thing is, of course, the immigrant investor has to decide whether they're going to pursue a standalone or whether they're going to pursue investment through a regional center. In addition to providing for indirect and induced jobs, a regional center investment also provides you generally with the opportunity of investing in a project with professional management and professional direction. Also, many large EB5 projects also have other investors other than the EB5 investors. So there is for the investor the acknowledgement that there are other people with fiduciary responsibilities who are exercising their due diligence in the review of the project and will give them added confidence. Now, the investor to begin with will file a Form I-526 with USCIS. And this is for their classification as a conditional permanent resident. If approved, the investor may obtain the CPR status once a visa is available. And this is very important for potential investors to understand. When your 526 application is approved, that means you qualify for a visa. It does not mean one is available. There are all kinds of regulations which generally restrict the number of visas that are issued in any category to 7% for the nationals who have a country of birth of a particular country. We're seeing this now with residents of China. I've heard, in fact, I've heard the EB5 blogs that perhaps Vietnam is also one of the countries where there soon may be a wait for EB5 investment, or a wait to get a visa. Now, assuming you're approved, the immigrant investor is approved, they make their investment, they come to the United States, they're expected to create 10 permanent full-time jobs within a period of about 2 years. 90 days before the anniversary of their entry into the United States, they file a Form 829 requesting that we remove the conditions and they become a lawful permanent resident of the country. What happens if all the jobs haven't been created in 2 years? Well, USCIS is well aware of the fact that schedules can slip, permits for construction or whatever can be delayed, and so we allow a reasonable time thereafter. If you have submitted your I-829 and you have not yet created the 10th or the 11th, the 9th or the 10th job for a particular investor, but you are on track to create those within the next few months, certainly that 829 is not going to be denied for that reason. Now let's talk about the regional centers. As I said, they're about 98% of our applications. Participation in the regional center program, as all of you I'm sure know, requires a Form I-924 with a business proposal. And that business proposal must focus on a specific geographic region of the United States and determine how it will promote economic growth, how it will, in verifiable detail, how it will create jobs, whether they're direct or indirect, a statement regarding the amount and source of capital committed to the regional center itself, a description of the promotional efforts they're going to take, the regional center is going to take, and production is how the regional center will have a general positive impact on the economy, and that evidence is necessary to be supported by an economically or statistically valid model. One question that comes up frequently is, why didn't you approve my regional center for all 48 contiguous states? All I can tell you is what we have said before, and that is essentially the law is a specific geographic area of the United States. It is not defined in law. And so we use economic arguments and economic logic to try to determine the appropriate size for a regional center. The appropriate size for a regional center can be defended by the scale, the scope, and the interconnectivity of the projects presented, and by other means as well. It's important, too, to realize that this is a point of statute. This is not a point of economics. As I point out, capital market requirements do not require regional centers. It's quite possible to have one office in New York, a few offices around the United States, and promote economic growth on a grand scale. There are firms that do that: Morgan Stanley, Goldman Sachs, JP Morgan Chase, and others. But the law requires for a regional center to operate within a designated geographic area. That, unfortunately, in terms of corporate finance, is not negotiable. And so I urge you, as practitioners, to look very carefully at your examinations and make sure that you are not claiming some kind of overreach in requesting geographic areas. More on regional center applications. There are different types of proposals. As I mentioned, when you apply for a regional center designation, you present to us a business plan. Now, that business plan can be a hypothetical business plan. The hypothetical business plan is only good to secure your designation as a regional center. It's not an approvable project necessarily. It doesn't comply with our decision matter of HO that lists all those great requirements and legalese of what is required to be a responsible and credible business plan. Or you can file the actual business plan, and this is valid for the designation of a regional center if you're seeking your initial designation, or when you're presenting the project to USCIS for adjudication for specific approval of that project. An actual business plan is where you have to have matter of HO compliance, where you have to show that there is a valid marketing study, there is a valid your permits, your other regulatory requirements from entities outside the USCIS are approved, as well as those of the USCIS, and that you present to us at least your revenues. I love the way it is in matter of how someone wrote this. It's the revenues, expenses, and the bases therefore. If an economist had written it, they simply would have asked for performance. And I can't urge you more strongly that performers serve a great use when you submit them with your business plan. A performer is a guidebook. I can write you a brilliant narrative, or I couldn't, but somewhat good, on how to build a house, but it would really help if they also provide a blueprint. It cuts down on the chance of mistakes, of misinterpretation, et cetera, et cetera. Most plans we get are fairly well written, and some are exceptionally well written. But there's always some ambiguity. As they say, English is a tricky language. Also, you have seen those projects day in and day out. You know the text and the subtext. We don't. And I assume a great number of you are attorneys, and you probably read contracts and legal documents every day. You probably don't read something one time and think, totally got it. You probably have to think about it, and you probably have to ask at least yourself some questions. And that is why you get requests for additional evidence when you do. And as I've said at other engagements, I truly hope you understand when we send an RFE, it is not a question of your intelligence or your integrity. And it is not an indication that we are stupid. There are other indications of that. But we have looked at this and reviewed it, and there is something we don't understand. So please provide us the information, and we'll resolve that as quickly as possible. The reason I talk so much about performance is because when you give us that information, it's corroborative information of your business plan. We can look and we can see the numbers, we can see the cash flows, we can see everything, and it ties it all together. Performance have two very valuable very valuable uses. One is as pure evidence, but the other is as efficiency. Because if I don't have a pro forma, and when I was first started out and I was adjudicating cases, 40% of them didn't have pro formas. That didn't mean I denied them or automatically RFE'd them. Sometimes I would work through them, but I guarantee you I could have adjudicated them much faster if I had had that extra bit of information.
Can you guys tell that pro formas are John's favorite thing? Just keep in mind, he makes great points. Keep in mind, though, it is not a requirement under the policy or the reg. Merely, it's just a suggestion for ease of adjudication.
Sure. Let's see. Now, let's say we get your business plan, and it's an actual business plan, and it is accompanied by your economic analysis, which an actual business plan has to be, and that it is also contains the contractual documents, the organizational documents relating to the new commercial enterprise and the investor. We look at these, and if we find that they meet the regulatory and legal criteria of the program, that we can give deference. We can put those in a file so that subsequent I-526 petitions can be given deference if they are based on the same documents. And that saves us a great deal of time as well. The process for regional center investments, first of all, you have to get approved, and then that's done by filing a 924. And then when you have a project, you have one of two choices. You file Form 924 as an amendment in which you present the investment to USCIS. Most people, and we understand why, do not present projects to USCIS on 924s. They do it on 526s. This is because of the backlogs that we have, and we fully understand that. We hope that you also understand that this creates an administrative burden, because let's say we have a question on the project, a simple question on the project. We can't send one RFE to the regional center, then say, what do you mean? Or even an RFC, a short email, do you mean this or that? Instead, we have to send an RFE to each of the, let's say, 500 investors. So you can imagine the coordination, the effort of getting these letters out, of getting in the responses, of dealing with those who don't respond. It places a lot of extra time in the adjudication of cases. Once we review the documents, whether they are presented to us in a 526 or 924, we review them to see if they meet the requirements so that we can grant deference. If we can, then subsequent adjudications are made much faster. Regional center structures. Most regional centers now are private, in the private sector, but there's nothing that says a regional center cannot be a public sector, or a hybrid. A regional center, unlike a new commercial enterprise, can be a not-for-profit. Here we have the structure where you have a regional center that oversees new commercial enterprises. The one in the yellow really represents the new commercial enterprise as the job-creating entity. This is rather rare. It's much more common in the standalone investments. The one in the middle in green, the new commercial enterprise, is a single investment into a single job-creating entity. That's the majority of what we see. There's nothing to prohibit the new commercial enterprise from investing in a portfolio of properties or projects. We don't see this very often, and quite frankly, we don't know why, other than this doesn't seem to be what the market needs. I will remind you that, well, not you so much as those overseas, that an immigrant investor can only invest in a single new commercial enterprise. Many projects can be funded through that new commercial enterprise, but the investor's investment is restricted to the one. Why EB5? After all, we do know there are delays, there are backlogs, there are a lot of papers you have to file. Why go through it all? Well, quite frankly, there is a lower cost of capital compared with comparable conventional sources. Also, if the EB5 is used as subordinated debt, which is quite common, it avoids the restrictive covenants of senior debt. It prevents equity dilution, that would require the sale of additional shares. It preserves the developer's control of the asset and captures for the developer the upside potential for the gain. How EB5 capital is used, and we heard a couple of comments while we were listening about mezzanine financing, and so I'm not going to belabor what mezzanine financing is, but that's where EB5 capital tends to go. We're aware that currently, and this was a couple of weeks ago, so it may have changed, the mezzanine debt rate is somewhere between 7% and 20%, depending on the relative risk. The typical monetary return to a new commercial enterprise is around 5%, and the typical return to the immigrant investor is less than 1%. People say, well, why? Well, economics talks about implicit reasons, and the implicit reason for an immigrant investor to invest is for lawful permanent residence in the United States. So they're quite willing to sacrifice monetary gain, except for the nominal amount that they earn from the NCE, in order to acquire lawful permanent residence in the United States. That carries a great value. I'll show you a few slides on capital investment in the United States. In 2015, total capital investment in the United States was approximately $3.6 trillion. I want you to notice, too, where that little bump goes down at around 2008, 2009. Before that time, EB5 was a rather sleepy little program that no one paid any attention to. But along came two things, a convergence of factors. The one factor was the financial crisis here in the United States, which meant that lending essentially dried up. Another thing was the phenomenal growth in the Chinese economy, where 83% of our petitioners come. This led to an increased interest in EB5 capital, and I will show you the reason for these slides shortly. But just to give you an idea of what foreign direct investment contributes to the United States, there was approximately $506 billion in foreign direct investment in the United States in 2015, which is a substantial amount of capital. The United States is the number one country in attracting foreign investment capital because, quite obviously, we have a legal system, we have a system of property rights, and we have systems of corporate governance, which makes investment in this country very attractive vis-a-vis other countries. To give you an idea, EB5 is a small portion of this, but a significant portion. We commissioned the Department of Commerce to look at 2 years to give an idea of what EB5 contributes to the American economy. In the 2 years they studied, which were fiscal years 2012 and 2013, EB5 contributed approximately $11 billion to the United States economy. And rather than producing 10 jobs, generally produced 16 jobs for every immigrant investor. So that we regard as a significant contribution to the economy. When you average the numbers out, that comes to a contribution to the United States capital stock of about $5.4 billion per year. Money that would not be in this country were it not for EB5. We'll talk about some other issues, and these issues may actually be of interest to you as practitioners. One is the backlog of regional center applications and immigrant investor petitions. Another is program integrity. We have a large backlog, and I'm sure that all of you are aware of that.
You're shocked to hear that, aren't you?
Yes, I know. Now, I'm not going to tell you anything, but can you guess, by looking at this slide, when the program was scheduled to sunset? Well, if you guessed in 2015, you were correct. And we had a huge spike of people applying and getting in applications for regional centers to try to avoid the sunset. We received, over the course of the 2 months of September and October of 2015, the equivalent of 2.5 years worth of I-924 applications. Now, hold that thought for a moment, because there's the I-526 applications, which also soared. Hold that thought for a moment and remember what I said earlier, that a regional center doesn't necessarily have to present their project on an I-924 amendment. They can also present it to USCIS on an I-526 petition. Roughly 45% of those petitions were presenting projects to the USCIS for the first time. And we talked about the difficulties of that administratively, et cetera.
And he's been kind in not saying the state of which these applications were submitted. They were maybe a little less than thorough.
Oh, I'm getting to that. Because of the uncertainties anticipated in these, of course, we had not only a surge of volumes of the applications, but as Julia pointed out, the applications were not, many of them were not of the highest quality. The economic term is garbage. We had a lot of applications that in no way provided even the basic information for approval or decision. And of course, this does one thing. It eats up time. And that's why our processing times are quite long. The good news is we have finally made our way through that series of applications and are now getting the regular standard of applications that we are getting now. There are, for regional centers, 3 things that really affect your processing time. One of which you have control over, the other 2 you don't. The first is your place in the queue. Are you number 39 or are you number 390? Can't control that. The other is applications 39 through 389. What quality were they? And how do they either keep the system moving or slow down the system? and the other is the quality of your application, which you can control. We'll talk a little about regional center terminations. This goes to the crux of program integrity. I'm sure all of you read about some misappropriation of funds that have taken place in different regional center projects in this country. It's very disturbing to us, and we are doing everything we can, combined with the knowledge and the efforts of our law enforcement partners and with the Securities and Exchange Commission to deal with this as effectively as possible. To give you an idea of what has happened in terms of terminations, and this is taking away a regional center's designation. Between May 2008 and September of 2015, USCIS terminated approximately 173 regional centers of the 974 that had been approved through that date. 137 of the 173 regional centers were terminated because they failed to file their annual report, their I-924A. 36 regional centers were terminated for the failure to promote economic growth. The failure to promote economic growth, for the most part, wasn't a misuse of funds. It was simply not having any projects within a 2 or 3 year period of time. But nonetheless, when you don't serve the purpose of the program, we terminate those regional centers. We're often asked about the complexity of our system, and we realize that EB-5 securities are private placement securities. They do not have the traditional continuing reporting requirements of securities issued on the stock exchange. They do not have the same disclosure requirements. They have different elements required for their prosecution in the event of misappropriation or malfeasance. But nonetheless, there was a wonderful study that was done. I don't have it with me, but if you are interested, I'll be happy to send you the link. It was a longitudinal study done between 2005 and 2015 that looked at the financial fraud in the regulated financial industry, the brokers, the traders, the financial advisors, the people on Wall Street who are regulated by the SEC. And that fraud rate was about 7%. I can tell you that our rate for known fraud, suspected fraud, and cases where we're investigating where there may or may not be fraud, when you add together that percentage, is far, far less than the 7%. And I have to say, as a matter of disclosure, that has nothing to do with me, unfortunately. That has to do with some wonderful people on this next slide. First of all, there is our Fraud Detection and National Security unit. And this tells you what we do to preserve the integrity of the program. Our FD&S people in pre-adjudication look at every application and virtually every petition to ensure that bad actors, known bad actors, are kept out of the program. They also look at this to make sure that no threats to United States national security come through. In the adjudication phase, you have economists and you have adjudications officers who are looking for strange clauses in contracts, who are looking for things which may eliminate or significantly reduce the possibility of a gain, or things that just don't look right. And when we see those, they go to the appropriate authorities for investigation. I tell economists, we're the thin red line. We actually look at the business plan, and this is why we RFE you and for other people, because we want to make sure we understand it is exactly what you are saying. Because from our experience, the vast majority of times, it is whole and it is complete, or it can be explained, and there is no hint of wrongdoing. But in those cases where we have noticed a pattern of activity or information which can indicate fraud, we are going to question it. The next is our post-adjudication. In our post-adjudication, we have the Fraud Detection and National Security Unit, and they do random site visits. And as well as for-cause site visits. I was privileged to ride along in one of the site visits, and it was a very pleasant experience for me because there was an economist who was very concerned about a particular project and the timing, and we couldn't find anything on Google Maps, or we couldn't find anything to indicate that the project was going on. And when we arrived in the city, we drove by this project, and it's a massive project well underway, and it confirmed that it was a viable project, it was well underway, and there was no need to further investigate. Now, we also have ongoing work done by both FD&S, and they administer the information sharing agreements we have with law enforcement agencies and with the SEC. We also have a new unit, the compliance unit, and they do the reviews of the annual filings of regional centers. As you know, we have redone the Form I-924A. We understand there is some confusion about some elements of that, and I think we addressed at the National Stakeholder Engagement that we may be putting out a correction or at least an advisory on a particular element, and I'm sorry I don't remember the exact details of what that was, but quite obviously we don't want you to be confused about the filing of the 924A. We also do compliance reviews of regional centers, and this may involve on-site inspections. And our compliance unit is also responsible for the actual termination of those regional centers that either fail to file or fail to promote economic growth for whatever reason. That's really the conclusion of my show, and I thank you for bearing with me. I hope this has been particularly informative to those overseas, and I thank you for your time and your attention, and we'll go to questions.
All right. You've got three of us up here. What do you have for us?
Do we want to ask our question?
Huh?
Do we want to ask our question?
Ask one first.
Fighting over the line. Thank you very much for coming today. My name is Julia Parker. I'm from Advantage America EB5 Group. John, just to answer your question of why don't more NCs do multiple projects, it's about timeline because of the 30-month rule. It's hard enough to get one project to fit into the requirements to do multiple projects in that fund model. We've looked into it, and it's just very, very difficult to do. I think that's one of the reasons why. Two quick questions. About the policy manual now that we have online, which is very helpful. Before we had the policy manual, we had the guidance memo that was kind of carved in PDF. Now we have the policy manual that seems to be updated almost real time. Mm-hmm. And it's kind of hard to keep up. Are there any plans to maybe have a website that sometimes you can change a little bit, like an and to an or, which has big impacts, and the industry is basically relying on one blogger, who, Suzanne, who basically downloads everything and blacklines it in her free time and shares it with us. But if there could be a formal process of being notified when there are changes to the policy manual, that would be very helpful for the industry.
There actually is a formal process.
Is
Anytime
there?
we make a change to the policy
Is it
manual,
me?
there's an alert that goes out that says the policy manual has been updated, and it very clearly says which sections, everything. So if you're not seeing that,
Well, I have received them on occasion, but for example, when you took out the 924A, well, when you added the 924 amendment filing requirement for geographic expansions, for example, I think the entire industry missed it. And if you'll recall,
that was done in the, if I remember correctly, that was done as part of a form revision, which goes through the Federal Register process. And yeah, I think you're right. I think a lot of people miss that. So I would just advise, if you're doing this work, pay attention to both of those sources.
Yes, we pay attention. And even then we miss them. So, well, thank you for that.
We'll try to do a better job of making sure we mention that in
Mhm.
our stakeholder engagement events that we have as well.
And we appreciate you being here as part of those efforts. Second question, regional center terminations. You mentioned 2 or 3 years of non-economic activity. I do understand the interest of the USCIS in needing to kind of keep the numbers in check, because there are hundreds and hundreds of non-acting regional centers. That said, it takes a very long time and a very high cost to get a regional center approved. For example, our group has 6 regional centers. When we started the process, say in Nevada, we had a project in mind. It took us 2 years to get it approved. Along the way, the project went away. We clearly have intentions of having future projects in Nevada, but this year, for example, I mean, not case specific, but just for example, it's been 3 years and we're expecting a termination letter. We're very active in other states. And so if you could rethink your policy of the 2 or 3 year just kind of almost automatic cutoff now that we're seeing recently, where regional centers are just being terminated. If you could have maybe 4 years, 5 years, a little bit, give us a little bit more time. That's also, I believe, in the best interest of the USCIS as well, in a way, because we're filing our 924As, we're paying the filing fees. If the law changes and we're required to pay $20,000 a year to keep that license alive, that's a source of income as well. So I think if we can work together to kind of find a middle ground instead of cutting us off after 2 or 3 years, that would be helpful.
Yeah, keep in mind it is not a hard and fast rule 2 or 3 years. And it doesn't, we do look at the totality of the evidence that you submit. So if you are making progress towards a project, submit everything you've got. We will consider all of it.
Yes, and remember, it's not a summary execution. You're sent first a notice of intent to terminate, and you do have the plans to respond to that and present the evidence that a project is under development or is underway, and we certainly do consider those. And a lot of regional centers have not been terminated for 3 years of inactivity because they are showing us, yes, we have something on the horizon.
Thank you.
Yeah.
Hi, my name is Jinhee Wild, and I'm from Washington, D.C. area, so we all had to come up here.
You're
thank
welcome.
You. Thank you very much for joining the industry people at this kind of conference. It's first ever, and this is very exciting. There are a lot of EB5 practitioners that are new to the industry. I've been doing it for 10 years, but they're new, and I think your explanation today, overview, was very helpful. One in particular that struck me is that overseas, I have seen some of the migration agents or investors misunderstanding the I-924 designation application with hypotheticals as being sold as a equivalent of exemplar application with actual plan, which is completely different. And people are saying, oh, we got the exemplar approval, so that's all good. And what it really meant was the designation application only. And I think your explanation of why that is different was very helpful. So thank you very much.
Great. Well, we appreciate that, and it's really good feedback. So it sounds like we should do a little bit more of that and maybe publish some things on our website. Great.
Thank you. I also want to extend our thanks to you for this outreach. And I can tell you it's not only China who are watching today, but it's also people in the UK and in India and in the UAE. We've tried to get as many people as possible.
That's so great.
One of the big issues, which I'm really glad, John, you did state, was some of the reasons for the delays, because literally on a daily basis, we're dealing with clients who are upset, who are asking us to do federal litigation, anything and everything to speed up their applications. Perhaps they have, there's so many issues, their OPT is running out, or there's other issues that they have emergencies for, which we all understand because these are human people and everybody has something or another. When you have a project that has already been approved, you've stated many times, not just today, but in past stakeholder meetings, that there is a deference accorded to that. How would you like immigration attorneys to show that deference? Do you want a big pink piece of paper, or blue, or red, right at the beginning, showing approved project? Or, you know, how would USCIS understand how you would like to see this presented? I know our firm does give a list of approvals, but I don't think everybody works in that way, and I also am not sure whether you notice it. So that's one of the questions. The second one is we have a number of expedited cases where the cases have been approved as an expedite. However, they're stuck because the project hasn't been approved. What do you do in those situations?
Mm-hmm. So let me answer the first question. If you're submitting 526s and you've already gotten an approved exemplar, we talked about this in our stakeholder engagement on Tuesday. Send us a list. When you send in the 526s, or you can send it to us via email. We've already gotten one since our engagement. One of our stakeholders sent us an email saying, you asked for this, here's the list of 526s that are pending associated with the exemplar. That's great, makes our jobs a little bit easier. We do what we can to kind of research and make sure that we're capturing it, but you know, our systems are not perfect, so we don't always catch it. So if you want to let us know, send us an email or a cover letter. That's super helpful. We really like that.
Deference in huge letters?
It's not really about deference, it's about these are the petitions associated with an approved exemplar, right? Because it's really just a matter of us matching them together and then making sure that they move to the floor. If the exemplar is approved, then we're not going to redo the project review or adjudication with the petitions if we've already done it on the 924 exemplar, or vice versa, right? It doesn't matter. We want to do that one time and then move the rest of those I-526s to the floor to be adjudicated. It's not terribly easy for us to do that matching on our own. It's a bit of a manual process. So if you include that information for us, it's really helpful. And then to answer your second question, the approval of an expedite, this is commonly misunderstood in the entire stakeholder community of USCIS. The approval of an expedite means that we're going to move the case to the front of the queue. We don't speed up the actual adjudication. The regular adjudication happens. There is no shortcut in the adjudication. We don't do anything different in our adjudication. It just means we take that case from the middle of the line or the back of the line and move it to the front of the line. That's once we've done that, expedite's done. That's the expedite. So hopefully that helps understand that a little bit. Doesn't mean that you can't send an email to our customer service team and follow up with an inquiry.
Thank you.
Mm-hmm.
Hello, and thank you very much for coming today and talking with us. My name is Ted Gilman, and I own and operate a SEC-registered broker-dealer. I have a due diligence question. In doing due diligence on regional centers and the sponsors of regional centers, oftentimes there are sponsors that operate multi-jurisdictional regional centers. I've yet to come across one that is a registered investment advisor. Nevertheless, it seems like there's a lot of investment advice going on in the industry with respect to immigrant investors. So my question is, has USCIS in its interagency discussions with the SEC or others had this issue arise with respect to investment advice that's being pro-offered to immigrant investors. Thank you.
Yes, we are in communication with the SEC, which has jurisdiction over investment advisors and over broker-dealers. I know the SEC is very concerned to make sure that unregistered broker-dealers are not operating anywhere, including an EB-5. I'm not an employee of the SEC, so I can't tell you how they are looking at the due diligence of regional centers, et cetera, or whether they recognize them as having fiduciary responsibilities. I honestly don't know. I can say that if you do have a concern, you should report that either to FINRA or to the Securities and Exchange Commission, because they are very diligent in their enforcement activities.
Thank you.
Again, thank you for coming. Everybody says that. John Pratt with the Kurtzman Law Firm in Miami, Florida. And I've asked this issue before as it relates to denied I-829s. As we know, the regulations provide that they're continuing to be lawful permanent residents. It used to be in the adjudicator's field manual that the CIS had to give evidence that they continue to be lawful permanent residents because they can renew that application, the I-829, in removal proceedings. The problem that we're seeing, and as we're litigating some of these investors have I-829 denials, you're dealing with different agencies, and it was omitted from the policy manual that CIS is required to give them proof that they're lawful permanent residents, obviously until there's a final administrative order through the immigration court or the Board of Immigration Appeals. But it also has affected CBP, for example, when you're having some of these residents with a denied I-829 coming in through the border, and CBP believes that they should be in removal proceedings or that they're paroling them in when they're really lawful permanent residents, and under the regulations, they're not even seeking an admission. Again, and I asked this issue on Tuesday at the stakeholders, and you mentioned you're looking into it, but if you could update the policy manual to bring it in conformity with the regulations, BIA case law, and the former guidance that was provided in the adjudicator's field manual, and it would be prudent sooner rather than later, because obviously certain people are being affected by the different interpretations of different CIS offices throughout the country in issuing the stamps and or CBP officers allowing these investors to come back in to the United States. Thank you.
Hi, I'm Bill Cook with Global Migration Law Group in Washington. Again, I also want to thank you for coming, and Jan, I thought your presentation was a great high-level overview of the program. I'm glad it's going to get widespread dissemination around the world on YouTube. I was wondering if you could expand a little bit on the office's expectation with regard to the nexus between invested EB-5 funds and job creation, particularly in the context of risk reduction mechanisms like escrows until the approval of a 526 or the use of bridge loans.
Bridge financing is something that we're currently reviewing. As a matter of fact, I think particularly after the engagement, it became clear that this is very confusing. I'm not going to speculate on what our determinations are going to be, but I can tell you that it's more than I will take this under advisement. This is a key issue for us. We realize this is an absolutely critical issue for business, and we're going to move to get some clarification on it as quickly as possible.
If I might, from the investors, it's a key issue as well from the investor standpoint. There's a lot of projects in the market now where a bridge loan is at the core, so the juxtaposition between job creation, people entering into the project at the late stages, and the non-payment of the bridge loan are key issues that converge and potentially make the outcome different for earlier investors than later investors.
Understood. If you would care to, again, I'm not an attorney, so please don't send me a legal opinion, because I would simply have to take it to my counsel. But if there is a business reason or a business problem, if you can send that to us via our investor mailbox, and we'll give you that information, we will get to that as quickly as possible. Because, again, you're in a very important industry and a very important business. We don't want to be an obstacle.
Thank you very much.
Hi, this is Bonnie Cao from Advantage America EB5 Group. So in the Tuesday stakeholder engagement, you explained that the IPO now adjudicates the I-526 petitions largely on a FIFO first in, first out order, and you're asking our feedback as to potentially adjudicating non-Chinese I-526 petitions before you adjudicate the Chinese I-526 petitions, especially in light of the visa backlog for the Chinese, for the investors who are born in mainland China. We understand that this will give non-Chinese investors their green card benefit faster. This will also protect Chinese investors who have children who are potentially going to age out. However, we would also like to point out that this would also have an effect of potentially prolong the backlog for Chinese investors even faster. Because our understanding is that the Department of State does not capture the investors' data until the I-526 petition is approved. So if non-Chinese investors gets their approval faster, on a macro level, they get, like, there are more non-Chinese I-526 approvals sending to the Department of State on a faster pace than the Chinese approvals filing around the same period of time. So this will first make the backlog longer faster and potentially make the backlog longer just as a whole. So we would like you to consider that effect as well.
Actually, that's not accurate. We do provide State Department information on the pending 526s that we have in our office broken down by country. So they do know what's pending and the numbers.
So just a follow-up question, because recently we saw IIUSA made a FOIA request. Therefore, we can see that the approval rates of different investors of different nationalities, different countries. And we see that generally Chinese investors have a higher I-526 approval rate, while other nationals may not have. When you send out the pending numbers, does Department of State take that into account?
I cannot speak for Charlie Oppenheim. I do not know how he does what he does. Sorry.
Thank you.
Yeah. But that's a good point, and that's why we asked the question. We want to hear all of the different thoughts on that proposal. And I do want to get your question, but after this question, we heard some interesting things in the panel immediately before. You guys were talking about discretion and how we might use discretion in the EB5 context. And I will say to you, that's not something that we've heard from people before. So we would like to hear a little bit from you on that. We're just interested in what you were thinking on how we might use our discretion. I'm not saying we're going to, but I think it would be really interesting to hear your thoughts on that. So if you had a thought on that, after he's done with his question, we've answered it, we'd love to hear it.
I'll ask an easy one then.
Okay.
I'm Nemo Corp. Partner, David Herson and Partners. I think, Julia, I put your name in almost every email I sent to USCIS. So sorry about that. My question is on guidance provided in the stakeholders call on Tuesday after a filed project, filing an 829 with a new JCE. And the guidance on the phone call was that it is possible as long as it's the same NCE and same RC. Other than that being contradictory to prior guidance and approvals, mechanically, if you are withdrawing from or receiving a refund from the new commercial enterprise, you are no longer a member. So it would be impossible for you to invest in the same NCE. Also, that NCE will likely be dissolved, or you would never be able to get all NCE members to invest into the same project. It also overlooks the fact that the RC may not have another project. So if these investors are actually trying to migrate their money and comply with the regulations, the guidance on the stakeholders call is impossible.
So, yes, that's understood. I mean, so our guidance is just there's no black and white rule that's going to be a problem. I mean, you've named plenty of things, as you've stated, that would definitely make that pretty close to an impossibility. Obviously, you'd still have to show all the rest of the eligibility factors. So, I mean, that is something to take into account. You make a fair point.
Thank you.
Hi, Sam Silverman, Managing Partner, EB5 Affiliate Network. We own 15 regional centers that cover about 21 states. You've probably seen our name across your desk at some point, I would imagine. I have a question about kind of changing regional center sponsorship. We've been involved in a number of different projects where your investors were originally on another regional center that, in some cases got terminated, and then the investors switched over to one of our regional centers, or there was a dispute with the previous regional center. It wasn't terminated, but the project was still switched over to one of our regional centers. And there hasn't really been any formal, and subsequently some of those people who were switched over, got an 829 approval, or, there was positive kind of reaction from the service that, that was accepted. But there hasn't been any formally published, guidelines as to when a project or an investor can, under what circumstances, switch regional center sponsorship, and how that would have any effect on their petition timing or approval, if any. I don't know if there's any comments, or maybe you could just share some light on that type of a situation, because we are seeing a number of situations where regional centers that had one project have a problem, and then the license got taken down. Now, where do those investors go, and can they switch, and under what circumstances?
So we are looking to put out more formal guidance on that issue because it is a problem. But right now there are at different stages that problem obviously manifests itself differently. After the 829, essentially your time freezes at the 829. So if the regional center was around when you filed the 829, we will still look, and as long as you're otherwise still eligible on the job creations and sustaining the investment, you are still potentially approvable. However, a regional center change we have deemed as a material change. So at the 526 stage, or if as they're trying to enter or adjust status, that would be considered a material change at this time.
Okay, so you would just adjust the filing and reflect that, but it's not necessarily an outright, trigger for them not being approved or a switch not being possible.
For the 829?
No, I'm talking about earlier. For 526 approval, or right after 526 approval?
It's material
before.
change.
No, it is.
Material change, but not a material change that automatically means they're going to be denied.
No, it absolutely does mean that.
Yeah, that's exactly what it means.
But we've had situations where we've switched regional centers and investors have been subsequently approved.
If they haven't filed the 526, I mean, if they put the investment in potentially, I believe you could change before you've invested, before the 526 is filed.
Right. If what you're saying is there was a 526 already filed, and then the regional center was changed, and we approved it, we made a mistake.
Yeah.
Okay. Okay.
Sorry.
That's what I want to clarify.
So would you like to give us those WAC numbers?
Okay. Okay. Thank you. Fair enough.
He's going to leave now.
Thank you, Julia. It's Mona Shah again. The issue about the discretion. I've been doing immigration law for about 20 years after coming from the UK. And many of those years prior to doing EB5 were doing appeals up in the circuit court, etc. Countless times we won the appeal and it came down back to USCIS. And it would land in front of an officer, adjudications officer, for many different reasons. And we ended up relying on the issue of discretion. And discretionary, for example, somebody who had an asylum case, and he was granted asylum a year later at that time, because you had to file after a year, for his adjustment of status, and he would go for get his green card. And for one reason or the other, this particular case was denied on discretion. I'm just giving it in context. Mm-hmm. So every time we have a stakeholders meeting, or every time that we do have any kind of dialogue, you do get all of us attorneys coming, and you'll have the attorneys who will give you their little soliloquies about the investor who is in an unfortunate situation. And that's because, yes, business law. This is a very, very unique, unusual situation because we have the juxtaposition of heavy business, big projects, timelines, and then the hard lines of the regulations, which really don't have any flexibility, and then individual circumstances of individual people. So my request was at that point was that I'd like to see an element being introduced allowing discretion, not for something across the board, but on an individual case-by-case basis. Let that attorney or let that person be able to prove that they deserve to have their green card, they deserve not to their project not to be terminated, and have it on the issue of discretion and on the same guidelines that you use discretion in other categories. I hope that's a little clearer.
That is clear. I will tell you from our perspective, we don't see that in the statute. There's clear discretionary component to an I-485 adjudication.
Right.
We don't see that in the statute for the 526, 829, or 924. So if you see that, that would be a good thing to dialogue a little bit about.
Yeah, and let us know, because I mean, we'd be interested in hearing your thoughts on how where that would kind of show up in the regulations and the statute.
Because I think that would be the only solution for your harsh circumstances. If you're going to terminate a project, you're going to terminate a regional center and innocent projects get terminated as well, and through no fault of their own, or maybe there's a fraud case through no fault of their own. There are so many circumstances where, you do need to use the element of discretion. Well, thank you.
Yeah.
Hello, my name is Payman Attari. I'm president of ASA Investment Advisors. I thought I'd better own up because I was the one who brought up the discretionary question.
Great.
But what I was really referring to was more in terms of the financial regulations and the discretionary authority that an investment advisor has from an investor. And really that's something that as investment advisors have to report to the SEC if they have discretionary authority or they do not have discretionary authority over certain accounts. So what I was really referring to was the responsibility of, let's say, the fiduciary having discretionary authority. From that sense would mean that the investor is actually given you discretion to choose the investments on their behalf. Or if it's a non-discretionary authority, is one where the investor actually makes that choice and you're purely acting as the harbinger or the manager of that project. So I think what I was referring to was really acting as the general partner of the NCE and whether that general partner has a discretionary or a non-discretionary authority to act on behalf of the investors.
Interesting. All right, great. Thanks for that.
Yeah, I'll take a different crack at the discretion. I agree with you that the statute doesn't say it like in the adjustment of status context where you do a balancing, et cetera, but you do have discretion to set up policy, and one of those policies is what you announced this week and announced again here. When someone invested in a project, they're compliant. They were part of a regional center that had other projects, and they were bad projects. Bad things happened. By then formulating a policy that switching a regional center in that context constitute a material change, therefore a deniable petition. When you have an I-526 that will be denied or an approved I-526 that will have to be revoked because the regional center is being terminated and it's going to affect not only the bad projects but the good projects. And they, in my view, they actually qualify for everything else under the statute. They made the investment, they're creating the jobs, all the different requirements under the statute and the regulations are satisfied as it relates to those legitimate projects. The only thing that's being terminated is the regional center, which will then merit automatically a denial based on the policy that you're just outlining. I believe that also you have discretion to not do that because it's affecting everyone else and they're still meeting all the requirements. All you're doing is switching a regional center on a valid project that created the jobs, money was deployed, and all the other requirements have been satisfied, statutory and regulatory. And I would urge you to consider that because I do believe that they meet the requirement, but for the termination of the regional center, those investors and the projects and the capital infusion and all of that is going to be affected or killed.
Great, thanks for that. Thanks.
Hi, I'm Gary Friedlander from NYU Stern. Thank you for the opportunity. I'll use some discretion and ask a big picture question. As far as when you need, when the service determines that an interpretation or guidance is to be provided by the policy manual, as opposed to when it should be addressed in a regulation. Can you explain that?
No, I cannot. That is not the role that I have at USCIS. That's really never the role I've had at USCIS. I've been an operational manager. We have a whole team of people in our Office of Policy and Strategy that they are experts in the regulatory process. I'm not in a position to explain that.
Follow up to that.
Sure.
Because in the regulations that you proposed in January, there was a provision that addresses the concern that the previous gentleman inquired about, which was visa priority retention.
Yeah.
So if the regulations don't get finalized as quickly as some expect, is that something that perhaps you can address through a policy manual interpretation or some other kind of interpretation?
Yeah, probably not. I can tell you that our director has made it clear to us that as a government agency, his position is that we do things via regulation and very limited things via policy. So I would be doubtful that we would move in the direction of policy, something we were already attempting to do via regulation.
Thank you.
That would be unusual. Yeah. I think there's one more here and then one more here, and then I think we've got to go.
Okay, great. Well, I'm glad I don't have the pressure of being last. Again, thanks for coming, Julia, John. Really appreciated it. We've been asking the concept of discretion and the concept of the investor who does the right thing and is caught up in a bad situation. My question is related to that, but not exactly that. I'm a corporate and securities attorney. I run the corporate and securities group at Barth, Mukamal and Kleiner. So maybe the immigration attorneys in the room fundamentally understand the question I'm about to ask. But I've been a corporate lawyer for 20 years, did venture capital. In that context, an investor makes an investment. Let's say they pick a fantastic investment, creates tons of jobs. They get their money back in 3 years. When everybody goes home. Terrific. Under your regime, that situation where an investor has made the right choice of investment, created jobs, had their money deployed, they get it back in 3 years, they're getting deported. I don't really understand that conceptually. Could you explain to me why there's a need for them to sustain their investment when the investment has done and succeeded with what it was supposed to do?
I mean, the only thing I can say to you is that's how we interpret this statute, and we get that it is not perfect and it's creating some difficulties. The long wait times for a visa and the limitation on the number of visas has kind of created additional challenges there, but that is the way we are interpreting the statute.
Hi, everybody. Thank you so much for coming to New York. It's a very good chance to speak together, discussion. And I have a quick question. I come from EB5 Regional Center. We are in Manhattan, also the hotel developer. My name is Tong Zhang. I just came back from China last week, and I attend an investment and immigration forum that was invited 100 agencies, migration agencies in China. And we, during the conference, we met a lot of other programs from other countries, from Europe, from Australia. A lot of investors now, they pay attention to other projects instead of EB5 project in US because of the first visa backlog, and then the new law will be changed, a lot of uncertainty. I'm thinking about, since this is a chance we can exchange idea, most of the Chinese investors, about 70% will be, you're going to see the number will be going down in 2017. But now the question is, we learned about a lot of things the USCIS will try to improve this backlogs issue. You're going to use 10,000 families or maybe you use the other visa that you didn't use before. Or I learned from other attorney that saying, even though the investor cannot get their conditional green card, they can still get their V visa to come to US. I don't know, all of these strategies are spreading around people in the industry, but I want to see what exactly the USCIS is going to do. Do you have your plan to improve the situation, or what exact your steps in the future, in the near future, you can improve this backlog issue?
So what USCIS is working on is improving the backlog that we have in adjudicating the forms before us, which is the 526, the 829, and the 924. We're making some really good headway there. I talked quite a bit about that, the different things we're doing kind of internally with our operations, cross-training our economists and our adjudicators, kind of cleaning up some of our workflow streams, making that process a little smoother. But what I think what you're talking about is the wait times for the visa. There's really nothing that we can do about that. That Congress sets the number of visas that can be issued for any individual visa category. We can't go beyond what they set. And we don't manage that piece, the State Department does, but they're bound by the statute.
I see. Okay, thank you.
Julia, one more question? Just
Okay, one more.
One quick
One more,
question.
'cause I can't
I
resist.
just heard that you spoke at the steering committee meeting that you will put a 4 months hold on filing of petitions. Is that true?
I don't know anything about a steering committee meeting.
Oh,
It was
okay.
another Julia.
Oh, no.
I have no idea.
So USCIS does not have a plan to put a hold on accepting any new applications next year, at the beginning of it next year?
I have no idea what you're talking about.
Oh, okay. But that didn't come from you guys.
That wasn't me.
No. That's not you guys. That's conversations on the Hill in legislative reform of VB5. That if legislative reform is passed in a higher increase amount, moving away from TEA and a new market tax credits system, that there would be a 4-month hold in all new filings for USCIS to catch up. It's not comment from USCIS. It's
Fascinating.
It's proposed by the Senate to give you guys a chance to catch up.
Apparently, we need to come here to these engagements to hear about what's going on.
Anytime.
Wow. I'm glad we're here.
Any more? One more?
Do you have discretion to open up Chart B for the?
No.
You don't. Who has who makes that decision?
I believe it's a USCIS decision. It's certainly not an IPO decision, but there is some language. I think it's on our website. I'm not sure. I have had conversations with the leadership in our agency about that, and there really isn't any reason from the USCIS perspective why we would do that. So it's certainly not under IPO's control. It's an umbrella. No, there's not an interest in our agency for doing that. Mm-mm. Sorry.
Well, thank you very much. We don't want to be in between the reception and
Right?
you guys,
I know
so
there's
you can
drinks
continue
after this
about
for
the
you guys.
talks later on. Just very quickly, I want to thank everyone, USCIS, and particularly you and Jen for a great presentation. And also, I would like to thank Mona putting together this amazing conference. And one last thing, as you know, we are part of Zicklin School of Business, the Neiman Institute. And in the Institute, we do two things. One is we try to mimic our curriculum to the industry, what is happening in the industry. And this event really helps us a lot so that we can revise our curriculum and then put it in. Although we are already doing it, like Jen mentioned, in our pro forma analysis, when we are calculating the mass financing versus the EB5.
Awesome.
The second thing that we do in the Institute is really to lead conversation, discussion with the industry and the government so that we can really understand more and then network more. So thank you all for coming, and I enjoyed a lot, and I hope you did the same thing. Thanks.
Thank you.
you very much for coming.